Hello, Professor Gagan. Hello. Hello, Gagan. I'm able to
Uh,
see you.
yes, yes.
Good
Good
morning.
morning.
Good morning. We still have time, I believe. It's good that you have all. It's better to join early. We can check the audibility and things like that. Let's share this with. अरे परत मी आउट झाले का? Hello, Dr. Shockers. Good morning.
Good morning. Good morning, everyone.
How are you?
I'm fine, ma'am.
Who's this topic? Where are we?
Good morning, Professor Devinder Singh, sir.
Sir, good morning. Good morning,
Good
sir.
morning. Good morning.
How
Good
are you,
morning,
sir?
sir. I'm fine. I'm fine. I'm very much bit hesitant to speak in front of the qualified faculty because
Absolutely not a
surprise for
problem,
me.
sir.
It is no
Hello, Ragini
problem
ma'am.
when
How are
you are
you?
panelist.
Ragini ma'am, how are you?
Hello, hi, good morning, everyone.
Good
Good
morning.
morning, man. Good morning.
Good morning, all.
Good morning.
Good morning.
I am Dr. Anisa Sheikh, facilitator for this session, session 5.
Good morning, everyone.
Good morning.
Good morning, Meena ma'am.
Morning, sir.
Good to see you all today morning.
Good morning, Ujjwala ma'am. Ma'am, I'm experiencing difficulty in switching on my video. It says that host has stopped my camera. So in case if you could help me out.
Okay, okay, ma'am.
Bharti, we are checking. Just give us a minute.
All right.
Bharti?
Okay,
Yeah,
ma'am. Okay, ma'am.
we are checking. Just give us a minute. Yes, Bharti, we can see you all.
Yes. So, good morning, all. We'll start with the session 5, day 2 of Regional Conclave on Justice Education in Asia. We have started our journey yesterday with the topics and the presentations where all the presenters, they have presented their work with their work. Excellent work they have excellent work has been contributed by law schools and law teachers. Ahead, we are starting with the topic that is teaching methods, innovative ideas for social justice, law college initiatives. So, to attain social justice, of course, the methodology, the pedagogy has to be innovative, because with the traditional methods, we cannot reach to the latest updated justice for the people. So we have to change the pedagogy and we have to improve. We have to adopt new technologies. The students, the learners, they know where to get, how to get the content, how to get the law, how to know the law. So it is a responsibility of the law schools, law teachers to innovate, to introduce the knowledge, legal knowledge, and to complete the society by providing justice to the people. So, session 5, I welcome all the facilitators, moderators, and presenters. I, Dr. Anisa Sheikh, Assistant Professor, Bharati Vidyapeeth, New Law College, and facilitator for this session. I welcome Dr. Devendra Singh, along with me, facilitator for session 5. I welcome Dr. Bharti Yadav for moderating the session and Dr. Saslina Kamruddin to moderate the session. Now, I invite Dr. Devendra Singh to introduce topic for session 5. Sir, please.
Very good morning, and thank you very much, Dr. Anisha Sheikh. I am really happy to be associated with this conference where legal education and global justice is being discussed. As far as today's topic is concerned, that is teaching methods, innovative ideas for social justice, law college initiative. As a teacher, we all understand that the students, most of the time they spend in the classrooms. That is the traditional method, not only traditional method, but that is the method which is in vogue, that is in practice. Because teaching them concept or learning the concept, including social justice, that happens in the classroom, and subsequently the students go to the society, to the locality, or to the institutions. They see that what they have learned in the classrooms and how they differ, and how the different practices are there out of the classrooms. As a teacher, I understand teaching methods that teachers should focus on the leading cases which are there, which are decided by the various court, right from the Supreme Court to High Court and the trial courts. Not only the leading cases, but at the same time, the cases which affect the masses. No doubt there are petty disputes, but student must be aware that there are small disputes as well, which needs redressal. Most of the time, as a teacher, we focus that yes, students must learn the landmarks like Keshwanand Bharati, like Menka Gandhi, like UNR Rao, or like this. We are more interested that these landmarks are interested. Somehow the idea travels to the student's mind that if we are so big, we have to make a contribution for such cases. At the same time, it comes to oligothelish or something like other form of things where student can find the legal problems around them. It may be of child labor, it may be of e-teasing, and it may be of any type, the problems which are in surrounding. So first role of the teacher and of the institution is they should make the students learn the conceptual part, not only with very big cases and landmark cases, but also the small cases, so that student can learn. The second thing which an institution and law college can do is that they can adopt the villages, which is nowadays a requirement of the regulatory bodies like UGC and all that, and at the same time visit to the courts, visit to the jails, visit to the revenue officers, visit to the banks and all type of institutions where student learns that social justice is the need. Whatever they learn in the classroom is only the remedial methods, but problems are outside. If they see the people, those who really need justice, then student will demand automatically from the institution that we need to go to the hospitals, emergency ward where accident cases comes and people are being exploited in the name of MSCT and all that by the police and all that. So students will start attaching themselves like this, and when they become professionals, then they will be reformers. They would be the active social workers, not only the lawyers. And I think this is expected from the lawyers as well, that no doubt they are professionals. They are being trained for that purpose, but they must have an appeal to social justice. So the justice could reach the common man. I think the today's panelist has prepared their presentations in well-structured manner, their experiences in the institutions, and I hope they will deliberate and they will share their experiences through which all of us would be enriched. So with this few remarks of my own experience at my own university, again I welcome all, and I extend a very heartfelt thanks to the organizer that I am part of this, and I will get an opportunity to interact in this seminar. Thank you very much. Over to Dr. Anisha.
Thank you, sir. Sir, I totally agree with you as to the point when you said that we must focus on leading case laws. And if we are focusing on leading case laws, of course, the people and those who are affected and the students who will be, connected with the society. This point is, very relevant for the social justice, sir. Because if they are not connected, what will be the professional and in what way the professional will go? So I totally agree with you, sir. Before starting the session, I must introduce today's moderator. Dr. Bharti Yadav is the faculty at National Law School, Delhi since 2012. She has completed PhD on Comprehensiveness and Advocacy of Legal Services Authorities Act 1987 empirical study. Her area of interest and specializations are criminal law, research methodology, and legal aid and clinical legal education. She has organized various international and national seminars. She has also presented papers on various aspects of criminal law, access to justice in national and international conferences. Her research has been published in various journals and books. She has been involved in administrative reforms initiative at prison. She has collaborated with Delhi Service Legal Authorities. She has been resource person at Haryana Institute of Public Administration. Welcome to the session, ma'am. The second moderator, that is Dr. Saslina Kamruddin, is a senior law lecturer at Faculty of Management and Economics, University Pedican Sultan Idris. She has obtained her PhD in law from University Technology, MARA in anti-money laundering and criminal justice. Her interests are in AML and anti-terrorist financial laws, criminal laws, and prevention and countering of violent extremism related laws. She frequently publishes in all international journals. So welcome to the session, ma'am. We now hand over the session to moderators. Thank you.
All right, thank you. Dr. Anisha,
Hello?
thank you.
Yes, ma'am. Can you hear us?
Yes, ma'am. Yes, ma'am. It's just that we both thought of thanking and greeting you at the same time. So after the other moderator, I would like to take my turn.
All right, thank you very much.
Thank you very much, Dr. Anisa, for this warm welcome. And I would like to thank Dr. Ujjwala and all the organizer of this Gauge Regional Conclave to make us this part of learning and experience sharing. I was part of first regional conclave also, and it was very enriching experience for me, and I'm thankful to the organizers and in particular Ujjwala ma'am for roping me in for this second regional conclave also. And to start with today's session, I wish to inform all the participants of the session that we have 6 speakers in this session. And as the session is of approximately 1.5 hours, so each presenter can take 10 minutes. And all the participants of the session can write down their questions if they have any from the presenter in the chat box, and or depending on the time frame, we may take up their questions towards the end, where they can say that their question is addressed to whom. So I would like to start the first presentation of the day. And the first presenter of today's session is Professor Margaret Phillip. Professor Margaret Phillip is an associate professor and the director of the Legal Studies program at Damon University in Buffalo, New York, United States. Professor Margaret started as the director of the program in 2012, and the program achieved American Bar Association approval in 2017. Damon Paralegal Studies program has both a BS program and a 21 credit certificate program. Prior to working at Damon, Professor Margaret was a lecturer at the University of Buffalo Law School, where she taught legal research and writing to first-year law students. While at the law school, she initiated 2 clinical courses to assist students in developing legal skills and to promote access to justice. Both courses partner with organizations that collaborated with Professor Phillips on training and preparing the students for practical legal work supervised by an organization attorney. She has experience in civil litigation at the trial and appellate level and hundreds of cases in negligence, medical malpractices, discrimination, and civil rights. She served as a litigation association at Connor and Villardo and Phillip firms. And at Damon, Professor Margaret teaches law for society, legal research and writing, advanced legal research and writing, paralegal internship, paralegal senior project, and paralegal clinic. She has collaborated with local community organizations to create one-day clinics, such as Conviction Clinic. She has published articles on paralegals and ethics, trend in legal education, a regular column called Spotlight on Paralegals in the local Bar Association of Erie Country Bulletin, and authored a textbook on legal reasoning skill entitled Practical Guide to Legal Research Analysis for Paralegal Studies in October 2019. With this brief introduction, I would like to request Professor Margaret to start her presentation. And in case I have forgotten to add one more feather to her head, that is, she is a Fulbright scholar to India, and my university, that is National University Delhi, is hosting her. So she's working with 2 of the institutions, that is Human Rights Law Network and National University Delhi, and National University happens to be a university where I work. So with this brief introduction, I request Professor Margaret to start her presentation, and the time for each of the presenter is 10 minutes.
Thank you so much, Dr. Yadav. I feel very humbled to be in the company of these wonderful faculty and justice activists and justice educators today. I learned a lot from the speakers yesterday, and I'm thrilled to be here today. Thank you, Dr. Ujwala, Dr. Devinder, Dr. Anisa, for putting the conference together and for introducing the topic, and also for allowing me to speak. I wish to share my slides. What I've done, I hope that it is useful. What I've done is, let's see, can you all see my screen now? Yeah, so I thought it would be helpful to just give you my perspective on building a clinical experience in 2 different settings. I created a clinic in both the law school setting and also in my university setting. And as you may know, the legal education is different in the United States. We have specialized law schools, which are just 3 years, where people have, where the students have all finished their 4-year degree in general studies. And then and now I'm at a 4-year, I teach in a 4-year program, which is so people can go on to law school. So there's just a difference in terms of resources and the ability of the students. So I would just like to share with you some of the stories and how I was able to do it, and in the hopes that maybe it would be helpful, a helpful example for you. So I created 4 clinics. The steps that I took to create these different clinics, I considered needs, resources. I started small, and I was always trying to assess and reflect, both with my institution, the students, and the organizations. The model I used, more or less, we would call in the United States an externship model. So sometimes in clinics, I see an in-house clinic where the faculty themselves are practicing, taking cases, and supervising students. I was not able to do that for various reasons. That would not have worked in my situation. So I created an externship clinic. So the 4 examples that I'll be talking about today, at the law school, I created a volunteer writing clinic. And then separate from that, I created a clinic where I took students to a hurricane region in New Orleans, and we offered direct legal aid. At my own university, where I still am, I created an externship clinic where students work for different public legal aid organizations. And I created discrete one-day clinics where students can get experience offering legal aid and legal assistance with just one day. So when I say consider the needs, what I mean is my own needs as a faculty person, the students' needs, and the community's needs. So in both my faculty positions, I wasn't necessarily appointed to be a clinical professor, but I had the freedom, right, and the academic freedom to create a clinic, which was great. However, I did not have a summertime appointment. I did not have any administrative help, and I did not really have a lot of extra time. So there were certain limitations in terms of me creating an in-house, what we would call an in-house clinic, where I would take on cases and students would assist, right? Because I did not have summer, I did not have a summer appointment. In the US, we don't have sessions over the summer, at least at my institutions. And I did not have any administrative help. So I had those limitations. The students, what I noticed about the students and what you seem to be noticing in your region, they were very eager to get out of the classroom and into the community. So they're very eager to learn, and they wanted to do real work. Many of my students in both settings did not have a lot of professional experience. They did not have lawyers in their family. They had never been to a courtroom. So in the US, we would say that they're a first-generation lawyer, right? Or at my university, they might be the first generation to attend college. In my community in Buffalo, we have a high need. We have a lot of refugees that settle there that need legal help. We have a lot of poverty, and we have a lot of people that are not getting the help they need. We especially have a housing crisis with a lot of old housing stock, and the landlords are not necessarily keeping the apartments and the houses in good shape. So we have a lot of a big backlog in housing court and in family court. So there are a lot of needs. Then I considered the resources, right? I don't know if you can relate to this, but again, I didn't have a lot of resources. I had the dedication and the altruism of a justice educator. I wanted to contribute. I could see that my community needed me, and I could see that the students needed me. And I wanted to build a bridge between those. That benefits both, right? Again, my institutions could not give me, in the US, we would need malpractice insurance. They could not give me administrative help. They could not give me a summer appointment. So I had limited time and capacity. I could not take on cases myself. And with this, and I think I already talked about the needs of the students and the ideas, the idea that students maybe didn't have a lot of experience, wanted experience, right? And they maybe were students that would not be able to get their own internship in a legal setting. So I decided to start small. So this is the story of the clinics that I created. With the volunteer writing project, at that time at the law school, I was teaching research methods and legal writing. The way I would teach that is I would give the students a hypothetical problem, and that does work well. But I noticed that as good as the students were and as excited, they would often say things, they wanted a real problem. What would happen in real life? What kind of research would they really be doing when it came to working in the courts or for another attorney? So I think a lot of us have a network in our community with, and we have relationships. I have relationships with the NGOs in my community. So I spoke to the attorneys at the NGOs. Do you have a writing project that you could give my students? So I got 5 writing also, I was lucky enough to have small classes. So this might not work if you have a large class. I got maybe 10 writing projects. So that did create, that I did have the time and the ability to get the writing projects. So this meant maybe some background research, maybe some legal research. The court had some cases that they wanted a draft summary of before, handing it over to the judge. So there's all different real legal writing and research problems. So I gave those to my students, and what I would say in the US is we workshopped them. So I would review legal research, and the students would take turns presenting what they were doing, their approach. I would give feedback, and then they created a legal writing project, whether it was a memo or a summary or a research and writing memo, that they then handed to the organization. So they loved this. They also were supervised by the attorney from the NGO. They loved this because it was real. The other clinic I created at the law school while a lecturer, there was a devastating hurricane. Some of you may know, I'm revealing my age, in New Orleans. And there was a wonderful group down there that already had a network. This is very far from me, already had a network of legal aid organizations. So I connected with them from Buffalo. There was a classroom component. I prepared my students for what the legal needs were in that community and what they would be doing in that community. I brought then the students to New Orleans, and for a week, we provided full-time legal aid. So the students stepped in public defenders' offices, prosecutors' offices, other types of legal aid, offering civil legal aid, and they assisted in terms of research and writing, screening clients, meeting with clients, all under the supervision of an attorney. So that was very exciting for them. This was very intense. We had the option, we have a very short January term. So this was a 3-week course over a short January term. So we could do preparation and then travel, right? And then because it was for credit, they could, many of them could borrow the money to do this course. And then while we were at New Orleans, they participated in this network of attorneys and worked for attorneys. So the other example is the paralegal clinic I created at Damon. This is kind of a classic externship model. I'm not sure if that model exists in other law schools in this region. So again, I had the limitations where I couldn't take on cases myself. So I partnered with different organizations, and we have a classroom. I created a course where the students are placed with an organization and they do legal work for the organization, but we still meet as a class every week, and we practice legal skills. So I remind them, because we all know we need a lot of repetition to learn, right? So I remind them about legal research. We practice practical things. We do drafting exercises. We practice ethics. And we also learn about the context in which they're working, largely poverty and housing, as well as refugees. The good thing about an externship clinic like this, the students are working for another organization, right? And they are being supervised by another attorney. So that organization, if there are any concerns, I'm not sure, maybe you don't have the concern about malpractice insurance, but that organization is supervising them, right? The students get real experience. However, one thing I have seen over the last 20 years of creating initiatives like that, attorneys don't always know the level of the students, and they don't always know how to give feedback that's appropriate for the students, right? So we have the attorney, so it's kind of like, it's a collaboration, really. I like to think of it as a collaboration, two-way street between me, the students, and the attorneys that they're working for, many different groups. So the attorneys will come in and do trainings, and the students will have an opportunity to interact with them. There is some logistical work that I have to do, right? And I have to reassess. So an example of the reassessment would be the first time I set up this clinic, it was to assist refugee agencies. Then President Trump was elected, and the stream of refugees to our city went way down. There was no money, there was no time, there were no attorneys. The attorney organizations kind of melted away for a little while. Now, since then, they've revived. There was no place for my students to work. So I had to broaden the scope of the clinic. And I found that there were two organizations that did client screenings in the court, in housing court and in family court. And they needed someone, my students' level, a paralegal, to do the initial screening. So that's what my students would do. They would do the initial screening with a form of the client in the courthouse, right? Then the client and my student would meet with the attorney, the supervising attorney, and the attorney would then represent that client for the day in court, and also review the client screening with the student. So the student got to interact with the client, sit in on a client attorney meeting, and then be present in court if possible, if there was time, when the attorney was representing the client. So I don't have a problem finding need in my community because there's so much poverty, and it's a matter of finding a partner that I can work with. Lastly, I created, and this was maybe in some ways the easiest. So all those things I mentioned were semester long, and they were for credit. So they could be part of the regular curriculum. The last thing I wanted to mention was just maybe the easiest, because it doesn't really need any, well, for me, it didn't need any buy-in from the institution. And that was just a series of one-day clinics. And I know I'm getting up against my time, so I'll conclude shortly. So this, actually a state legislator, a state senator reached out to me and said they needed help doing these one-day clinics where people would get their marijuana conviction expunged, so eradicated, because the law has changed in New York State, and there's a new law that allows them to clear their record. So there was some logistical weight. We had to work out the different dates and times and places, but we had a lot of parties. We had the state senator's office, and then we partnered with another organization, right? And so we got we partnered with my university and me. So we got student volunteers, lawyer volunteers, and the state senator's office did a lot of the logistics. And then we would have the whole day, people could come in, and my students and the supervising attorneys would help the client fill out the form, and in order to get their criminal record expunged. So those were just a series of one day, no credit, but accessible to the students that could not maybe take a clinic course because it's not required, right? And accept, or maybe they don't have time because they're working. So just what I always try to do at the end is to reflect and get feedback. And yes, I can see that my time is up. I am just sure to ask the students about their experience, and I'm sure to ask the attorneys about their experience. Oftentimes there's issues, but they can be resolved with open communication. And I think that's necessary for the continuing success. So am I at time, Dr. Yadav?
Yes. Yes.
Okay.
Thank you.
And so thank you. I was just going to say thank you for listening, and you can take it from here.
Thank you so much, Professor Margaret, for giving us an insight to the working of clinics at your law school in particular, and in your country in general. I'm sure that we all must have got some innovative ideas to incorporate in our ways of offering clinics here. and you have got some message in the chat box also. And now I would like to request our next speaker, and I would like to introduce him first. Our next speaker is Dr. Shaukat Ahmed Wani, who is a serving assistant professor at School of Law, Mercy Monzi Institute of Management Studies, Bangalore, India. He has completed his LLB degree from University of Kashmir. He joined Indian Law Society, Pune, Maharashtra for LLM. After completion of LLM, he further completed his PhD from Aligarh Muslim University. He has so far written 29 research papers in various reputed journals, including Scopus Index journals. He has also presented more than 37 research papers at various national and international conferences. His key research areas include constitutional law, human rights, Muslim law. Dr. Wani has also contributed to valuable legal assistance to the under trial prisoners in collaboration with Tata Institute of Social Sciences. Dr. Ahmed Wani has 4 years of teaching experience and 4.5 years of research experience. Dr. Wani is very keen in research and human rights and also a strong believer in the power of positive thinking in the workplace. Dr. Wani has guided 4 research scholars from the last 3 years. Also, 8 LLM students have completed their dissertation. So with this brief introduction about our next presenter, Dr. Wani, I would like to hand over the floor to Dr. Wani to start his presentation, and we request you to present your presentation in 10 minutes time. Over to you, Dr. Wani.
Thank you so much. Let me introduce myself that I have a very less experience when we are talking about sitting in front of the huge experienced faculty and members so far as in the legal domain is concerned. And by starting, because we have a very less time, let me start before I'm going to the pedagogy, let us discuss about that how we are going to achieve the social justice. Like as we know that every society, when we are talking about from time immemorial, that it has been making its best efforts that to ensure at least that we should achieve at the basic level at the human rights, so far as each members of the fulfilling in the globalized world. Now, let me having this liberty to, in order to say that how we are going to achieve these particular principles so far as the social system is concerned in our society, which is unfortunately full of inequality and also discrimination and other things that which also conflict each other when we are talking about the human rights as well as the fundamental rights. Now, this particular concept, when we are talking about the social justice, which we are talking about, it is always being evoked with the ideas of equality and the proportion of the compensation. The compensation, I mean to hear that the justice, access to justice. Now, in order to, in short, we can say it's another name of libertarian concept. It's another name of egalitarian concept, and as well as the fraternity which we have, which we believe. Now, so far as the today in the 21st century, when we are talking about how we are going to evolve and how we are going to disseminate the social justice system among the students, so far as the colleges and universities, when we are talking about the legal studies concerned. Today, the concept of social justice often refers to human rights because we cannot segregate the human rights and the social justice, because these two are the inevitably interwoven. And also, it's impossible to have one without the other thing. Now, particularly when we are talking about the Asian countries and let me say also in India, now these rights, social rights are manifested in laws itself through by way of the Constitution of India as well as other statutory laws. But how far it is being implemented and how far it's not being implemented, that's a matter of debate, and that's the data which tells us the story. Now, when we are talking about how we are going to induct such a social justice system among the students, lawyers plays a very important role. Now, when I'm saying the lawyers plays a very important role in promoting social justice and peace by applying the law in that it reflects the basic requirements of justice. Now, if we recall one of the founding father of the Constitution of India, Dr. Bhimrao Sahib Ambedkar, what he has said about the social justice and how we are going to achieve its principles and goals. Now, social justice is based on the moral values and the self-respect. So law is not the only medicine which can cure the social justice, because it needs also other things. Now, justice through social, political, and economic justice regulates the constitution. Now, even if we really want peace throughout the world, then the social justice is the basic step we need to take. Now, through colleges, through universities, and also as well as through different, you can say, organizations. And I believe also that every democratic nation is considered as this incorporating these particular principles, so far as the national law is concerned, as well as the international instruments are concerned. They are prescribing the abuses of power and providing remedies to the victims of such abuses. But let me tell you one thing, when we are talking about how we are going to use the pedagogy, now we have to educate ourselves about the social justice. Now, so far as the academicians are concerned, we have to educate ourselves first that what is social justice and how we are going to induct such things in the curriculum. Now, social justice issues so that we can disseminate the same among the law students. Now, apart from, we have, you can say majorly, we can say we have the two segments of law. You can say the procedure law as well as the other laws. We take the example of the constitutional law, labor law, as well as environmental law. But these three laws, where we can disseminate also, we can train our students by giving them the personal experiences. Very shortly, I'm going to describe that now. Coming to the very shortly, I'm going to describe my own personal experience when I'm talking about the field study giving to the students, which I have given. I will share it with you. Now, coming to the pedagogy, innovative pedagogy, it does not come to the picture if the following tools are not facilitated. Now, any pedagogy in the world, when we are talking about the socio-legal issues, it cannot work properly if the following tools are not to be facilitated. What are these tools? These are teachers' qualities. Now, the teachers' qualities and attitudes towards modernization is very imperative. Now, so far as a successful teacher, these qualities and attitudes towards modernization can be achieved when we are going to induct, and every successful student and teachers must be qualified and trained as per their updation. See, once we are not being updated ourselves, day-to-day surroundings, day-to-day happenings, day-to-day precedents, day-to-day social problems, definitely we are not going to approach to our students through our curriculum. Now, when we are saying there is no strong relationship between innovative law teaching pedagogy and effective and efficient outcome, particularly in the developing countries, take the example of India, Pakistan, Sri Lanka, Bangladesh, and other Asian countries, we don't have such kind of, what we can call that optimism that how we can do, how we can take the drastic changes in our curriculum. The students learn the law subjects in different ways of methods. And the trained teachers are trained to shape the students by giving them the various activities. Now, the various activities are very important. What sort of activities we are giving, whether we are giving only the critical, analytical, or you can say the conceptual knowledge to the students. That's the moot question here that we want to ponder about it. And the practices related to that particular concept is. Now, definitely, I believe that the students will excel in their fields if there is a strong relationship between the innovative law teaching pedagogy and effective and efficient outcome. Now, how this efficient outcome is going to be achieved, I will share some what you can call some predictive measures, which I have personally taken in my during the 4 years of teaching experience. Now, before going that particular thing, let me tell you, take the example. I would just share one example so far as under trial prisoners are concerned. If we can recall, almost 77% are under trial prisoners in India. And out of 100%, only 22 are the convicted. Now, our jails are completely overcrowded with the under trial prisoners. And unfortunately, I have done my work with the clinical legal aid justice in Tata Institute of Social Science, where we have worked with the students. And also, when we have worked with the students, we have seen, am I audible?
Yes,
Yes,
sir,
sir.
you are
Yes, sir, you are
audible.
audible.
Yes, sir.
Yeah. So when I had started working with the Tata Institute of Social Science in a practical field that we have done in collaboration with the social science, and law is not the only subject which can go solely, because it's an interdisciplinary subject, particularly when I am talking about the social science. Now, in collaboration with sociology and Department of Law, we have done one field study to visit the jails. And when we have visited the jail for 6 months with my students, and we have seen a lot of cases, false cases, lot of poor people, vulnerable people, and the marginalized people have been languishing in the jails. And let me tell you, there was two stories I will tell you about these particular cases. I'm very blunt and candid by saying that so far as the DLSC is not doing any kind of a work when we are talking about the undertried prisoners in our country, and how now the students can approach, if we are going to induct, or also if we are going to give some kind of a field study to our students as a part of their curriculum, as a part of their education, definitely the social justice principles can be achieved. And you will be shocked that we have seen one person languishing in a jail in a simple food adulteration case for 9 years without any bail, without any hearing, not a single bail, not a single proceeding. And that particular person he's in a literally in a vegetative state. He was deep, not speaking. And also the other jail inmates, prisoners, they are being taking the wheelchair and moving them from one place to another place. And such kind of a shocking revelations came through when we have visited it on the ground. See, the law cannot be taught only through the benches in the classrooms. See, once we are teaching such kind of innovative things in the students, when we are inducting, disseminating the legal knowledge to the students, we should be assured that these particular concepts must be executed in the field. But unfortunately, very unfortunately, our curriculum system is very conventional, very traditional. The traditional, I mean to say that we are not thinking about the internal class assessments. See, we are giving just simply like, this is the topic where you have to work, and that gives only the theoretical, critical, and analytical approach. So once they are identifying the problem through data, to any kind of a research, but unfortunately we are not reaching towards the justice. That is what we can call access to the code, access to the justice. And students don't know how we are going to work on it unless and until the academicians, legal community are not going to incorporate and are not going to make changes in their syllabus, or we can say in the curriculum, then definitely the legal aid services, clinical services will not work. Now, let me share you an example here that how I have worked with my students while disseminating the, what you can call the education to my students. Is it possible that I can share some videos with you?
Dr. Shaukat, you have 1 more minute time, so you can utilize it.
Yeah, I can utilize it by showing some videos which reflect is very important thing. Is my what you can call is it visible?
Yes, it's visible.
Screen?
Yes.
Yeah.
Okay.
But the video is not visible. The text is
Yeah,
visible.
I'm just showing that. Is it visible now?
Only the text. Do you have link in this text, Dr. Shaukat?
Sorry?
Do you have link in the text which we can see on the screen?
Is it not visible to you, ma'am?
The text, the document, the Word document is visible to us, not the video. Do you wish to show the video or this Word document?
No, I think I'm showing this, what you can call I'm showing the video, ma'am. Is it not visible to you, ma'am? My
No,
screen is visible to you?
Now it's not.
Sir, I think you have selected that option of sharing the window. Instead of sharing the window, You can share, now it has been deselected, so you can go with sharing entire screen. Earlier it was window only.
See, I think I have shared. Wait, is it visible now?
Now it will be, sir. Yes, now it is.
Yes, sir. You can play now. Yes, yes. Sir, we can't hear anything.
I think there is some problem. I heard.
No, sir. Actually, just go back and while sharing the screen, click on machine sound. It will be audible then.
Dr. Shaukat, Dr. Wani, can we take it towards the end of the presentation?
Okay. Sure.
So if we remain with some more time towards the end of all the presentation gets over, then you can try. Meanwhile, you can try. And I request the student assistants to kindly guide Dr. Shaukat through the direct check messages that how it can be played. So now
I want to add. I would add with your permission that. See, so far as our curriculum is concerned, I think we should make legal aid clinic mandatory. Like we are giving just like in a street plays are not going to work unless and until we are not going to identify the problems of the social justice. See, once we are identifying the social justice problems, two problems I have to, my students have worked on one case and we are approaching to the Supreme Court. Only we are approaching to the Supreme Court very shortly for that particular cause so far as the disability is concerned. And this happened only when I have given the internal assessment field study to the student. And that has been proved very improvised and also given some kind of result. And the Supreme Court has accepted one PIL already so far as the environmental issue, one of my student, and also we're approaching for the another PIL in the Supreme Court so far as the disability is concerned. Because we have the short time, we cannot discuss all these things. So the lastly, that improvisation in the curriculum system that which has been based on the conventional methods as well as the traditional culture or the lecture methods need to be changed very swiftly. Thank you so much because we have the less time.
Thank you so much for this wonderful presentation, Dr. Wani. Now we would like to invite our next presenter. Our next presenter is Dr. Meenu, who is working as a professor in School of Law, Lovely Professional University. She is working mainly in the area of taxation law, including GST and income tax. Her other areas of interest include educational, leadership, outcome-based learning, and other associated areas. She has also been working on the awareness of the social issues in the society. She has initiated and conducting various workshops on RTI awareness in rural and urban setup. Her brief is to apply the educational learning in actual practice. She herself is a constant learner and keeps on improving her skills while attending various workshops and courses. These learnings are replicated in practice in different manners. She has also convened various workshop conferences and moot court competitions and other learning activities to provide exposure to law students. Her encouragement students as well as to undergo various kind of legal program to make themselves profession ready. Over to you, ma'am.
Thank you so much. Thank you so much for such a warm introduction. As if we have limited time to discuss.
I request Dr. Shaukat to kindly mute your microphone.
Okay. Send it to me.
Dr. Shaukat, we request you to kindly mute your microphone.
Thank you so much. So as if I already said that my philosophy is like whatever we are doing, we should be doing it with whole heart. As if my intention is to study the law and also to impart the legal education in the most practical manner. Before starting with this particular session, like I would request all of you to ponder upon certain facts, like what we have already been discussed about. It's all about the legal education that we are talking about. First of all, why do we require law in society? Like initially, whenever the society must have started, the law must not be the first thing that came into picture. Definitely, there have to be certain things which were not good, which were not sufficient enough And that's why we required law in the society. We said that this is how the system must be followed. This is how the rules and regulations must be there. And in case if there be any wrongdoer, how that person must be punished or the disputes should be redressed. That was the very first intention of introducing law in the society. Second thing is, as we people all are involved as a faculty in the current world, as if we have to provide about the current legal education that we are giving to the students, is it sufficing the purpose? Are we in a situation to provide actual law in the manner that how it was supposed to do? The purpose of law is to redress, of course. The purpose of the law is to punish the persons whosoever are the wrongdoers. That is how the legal functionaries, the legal institutions are there. But actually, as a legal people, are we actually intending it to do? And we as law schools, are we able to dispense such kind of information, such kind of knowledge and training to our students that they can actually do whatever they are supposed to do? So with all such things, considering like as my very amongst our work areas where I'm doing over here, it is an outcome-based education. We are aware of that. And the outcome for the education must be that whatever we study, it should be practical. It should be knowable for the persons concerned. Now, all of us are involved in the legal education. No doubt, I am very much convinced with the words as said by respected Dr. Professor Devendra sir in the very beginning, that we have to just stick to the concepts. We have to clarify the concepts of the students in the classes. Conceptual clarity, unless and until the conceptual clarity is there, we shall never be able to initiate the best things out of that. So first of all, clearing the concept through the best classroom teaching, that is primarily, I think, the role of the teacher should be. Secondly, once we go to for the application of the concepts must be through the legal education, that is the clinical practices, whatever we people are following. So in the meanwhile, there are various things to do. So all of us as the teachers, we people have been providing certain projects to our students, certain continuous assessments we have been doing. And I really respect and I really say to the all respected teachers that whatever the curriculum we are providing, whatever the basic informations we are, I will say it's information that we are providing to the students when we are saying that we are evaluating the law or we are understanding the law could be understood, the nuances could be understood. But once we come to the application part, thereby the application should be, it is a process which should be followed as a learning by doing. So learning by doing, thereby the students, I think they may be provided with certain kind of projects. The projects, as Dr. Shaukat was aware of, like he was telling us, like certain video the sir was showing us, I think I am able to get the idea, like how the students are working in the field, how they are actually understanding the issues of the society and what the role of a law teacher or a law student or even a lawyer could be there in the society so as to redress the problem concerned. So I think the video that was there, it was concerning certain laborers, how they are actually working, are they getting equal pay? Are they getting bare minimum wages, or what are the working conditions for the workers concerned? So all these constitutes the part of the social justice that we intend to impart to the affected persons. So as a regulator in the society, as all of us, we are enforcing the laws, we are just, you could say, supplementing the legal procedures itself. So are we actually doing what it intend to do? So the legal aid clinics are there in all our institutions. We are a BCI regulated course, but the BCI provides for certain complementary norms for us. It says that 36 hours of teaching must be there every week. Then BCI also provides that we should be having clinical legal education also. It says that the moot courts must be the part of the curriculum and so many other things. But how actually those are being implemented in the classes, how actually those are being implemented for the betterment of and training of the students, those are the questions which are definitely should be thought of. And as far as an institutional practice is concerned, we at the LPU, we are making much more efforts in the learnings of the students in the way that we are focusing on their trainings. We are focusing on the trainings in a manner that we ensure that every student should be undergoing certain kind of internships. The BCI provides that the minimum 20 hours of the trainings must be there for a 5-year student. And that 20-hour training, that means it should be spread across our curriculum. So we have made a setup that every student should be undergoing the trainings at least 1 month. I'm saying at least 1 month. which is generally extended to the duration of 3 months. For the 9 months, we have our classes and the semester and everything is going on. But the 3 months duration in a year, I think our students are benefited enough to get the curriculum, to check the curriculum is being implemented also. So they are being interned at various places. The internships, I will say that normally the students are going for internship in the course itself. But course is one of the aspects, but there are so many other things also. The other things include, like, first of all, I think the students should be sent to the NGO so that they could be able to appreciate the concept, like how actually the problems are coming up in the society. Because as far as we know that the problems comes first in the society, and at a later stage, we develop a law and we try to fix the problem. But what actually is the problem? What are the nuances of the problems that could better be understood by looking at working with the various social groups? So NGOs and training with the NGOs is one of the aspects that I will definitely endorse. The second thing is that as the students are actually looking at the working of the ministries too. Like these days, various ministries are offering for various internship opportunities. They just, you will say, advertise also on the social media portals also. Even the institutions like Law Seco, Law Octopus, etc. They're also giving the information where the internships could be done as such. So the ministries, they are also providing opportunities apart from the ministry within the parliament itself. There come certain opportunities for internships of the students. Then we are benefited enough, like our students are doing their internships not only with the advocates of the High Court and Supreme Court, but we managed to provide them internships with the judges of the High Courts and the Supreme Courts. So this is something, a very welcome note I have seen. Like our students, as they are doing their internship in the High Courts itself, like we generally send a request over there, and majority of the times it is accepted. And the judges, they do interact directly with the students. They let them know that how the law could be applied, or what are the actual challenges of the system, and what could be the probable resolutions out of that. They do suggest about that also. And a student to have very good exposure, that they know how the judiciary is working and what are the challenges or the limitations of the judiciary also. We normally say that in newspaper, we are getting the information, okay, this judge has given not a good decision, it is a bad decision or what else. But what are the driving forces behind that? Those must also be appraised too. And that is also one part of the system. Then another thing is that I believe along with the trainings itself, like we do have various commissions, like the Competition Commission of India. And there is a labor ministry, like recently some of our students, they have done their internship there too. So although normally for them, what happens is they do not provide for the internship at the time when the internship slot is kept within the semester. This is a challenge what I face as an institution. So as we know that the BCI is an organization, or BCI is a regulatory body which allows all of us that how we should be developing our courses. But thereby, I think I could, from this particular platform, I could endorse my point also that somewhere we need to cut down on the class hours also. So as far as the BCI says that so many classroom teaching must be there, so many hours must be invested in the classrooms, but it should be cut down. So unless and until we keep the students out of the classes and we just place them at the actual work area, we will not be able to teach them at the better places. So that training must be there. That's very important for myself. Then another thing that I say, that once we are remaining within the classrooms, in spite of going with all the kind of theoretical aspects, definitely that is very important. As a teacher, we will definitely say that the classroom teaching has to be wonderful. But along with that, where comes the aspect of continuous assessment? That continuous assessment must be practical in nature. Practical in nature, when I talk about that, the projects, of course, as Ashok sir was endorsing, such kind of projects we can also undertake. Then apart from that, we can also suggest our student to make a certain kind of survey, the social legal research.
Yes, sorry to interrupt. Your time is about to end. Can you sum up your presentation?
Ma'am, actually, I'm not sharing the screen. I'm simply speaking as such.
Yeah. I'm telling you, your time is about, your 10 minutes is about to over. Can you sum up your presentation?
Yeah, just ma'am. I'm going to conclude within 2 minutes only. Thank you. Okay, so I was telling you all about the practices that we people are following as an institution. That apart from that, I was coming to the point that we people have undertaken very good concepts with us. Like there is an integrated legal education. I believe that in majority of the institutions in India, the BA LLB or the BCom LLB programs are running over. So which are the 5-year courses. So as if these are the 5-year integrated programs, to my understanding, the faculty and the students must rethink upon the inception of these concepts. That why do we require integrated programs? Initially, I believe that when the Dr. Madhavan was there and he introduced this concept in the NLSIU Bangalore for the first time, he just tried to make an initiative so that both the things like the social sciences, as the law is also social science, whatever are the social phenomena and how the law could be applied over there practically should be thought upon. But today I am just checking the point, like we are not taking the idea forward as the way it was incepted to be. So the integrated curriculum, so BA LLB or the BCom LLB, whatever are there, those have to be there in the coherence, and all the courses must be in the sync as such. And my otherwise the area in which I am working upon is the taxation laws as such. Like some person asked me the point that we are generally not considering the taxation laws at such pace in the law, but I believe that such kind of concepts, because we know that in India, the commercialization is increasing at a faster pace. Whether it is a national education policy or we talk about the initiatives such as the Make in India concepts and all that. So thereby we know that the commercialization is it's a very important for all of us. And as if the commercialization is increasing, the commercial disputes are also increasing. So there I see a very big lacking in our part, like we are not providing any such kind of training to the students where they could appreciate whatever are the concepts, whatever are the problems coming in the commercial world and how those could be redressed. And thereby I see a lot of scope in the arbitration concepts. So normally the commercial transactions, normally everybody go for the arbitration, and that is the best way out that we could work upon. And I think that we can also incorporate in our curriculum as such. That's all from my side. Thank you so much. And I will be very happy to have any question from your side. Thank you.
Right. Thank you very much, Dr. Minufa, for a very, I would say, the thought-provoking ideas and also some inputs or some insights from your side. I'll be taking over the session, being the moderator for the session. I'll be taking over from Dr. Bharti, right? The next speaker that we have is, of course, Dr. Tuti Rastuti. Dr. Tuti, you're there. I can see you. How do you pronounce you, Dr. Tuti or Tisni Santika? Which one, Doctor?
Hello, ma'am. I will be presenting for our team.
Yeah. Okay. Let me have some introduction sessions. Today, Dr. Tisni Santika is a lecturer at the Faculty of Law, Universitas Pasundan, Bandung. She was awarded with a fully funded scholarship for her bachelor's degrees from the Faculty of Law, University of Pasundan. She earned her bachelor's and also master's degree with the cum laude predicate. Her area of interest covers intellectual property, company law, contract law, and her research articles has been published in several Scopus Index journals and nationally accredited journals. She has also co-authored and authored several books about the intellectual property, company law, and contract law, and currently serves as the editor-in-chief at Das Holland, Journal of Contemporary Research and Society. Dr. Tisni, the floor is yours.
Okay, thank you so much, Professor Lina, for the introduction. And I would like to take the opportunity to express my gratitude to Dr. Ujwala, Dr. Anissa, Prof. Indah, to gather us in a very enlightening session. I learned a lot from everyone of you. Thank you. So allow me to start my presentation. I would like to present Center Learning and Merdeka Belajar, or emancipated learning in Indonesia. This is an overview of legal education in Pasundan University. Okay. As we know that legal education is the medium for people to enhance the knowledge and understanding of law. And in legal education, we see that legal curriculum is one of the most important factors in shaping the competencies of the law student, and also one of the most determinant factors in transforming the education system and shaping the competencies of the law graduate. Based on the several cooperation projects by Bender and Fell, there are several major contemporary criticism of legal education in Indonesia. The first is the formalism, where the doctrinal nature of the legal education and the highly theoretical method leave the students with a lack of opportunities and freedom to expose to different perspectives. And then the second is the lack of skill as the result of the highly theoretical and also doctrinal nature of the legal education that do not provide the students with the relevant practical skills like presenting oral arguments, presenting educational material, writing legal opinions, and also counseling, interviewing, and also drafting contracts and others. And the third is about the teaching methods, where the teaching method is mostly done in the form of lecturing in a large group with a low level of interactivity and result in theoretical, dogmatic, and also formalistic approach to law. And the fourth is about the teaching materials, where there is conservatism regarding the use of the teaching materials such as textbook and also regulation that are often not very up to date or less relevant to the development of the society. In the year 2020, our Minister of Education, Nadiem Makarim, launched the program named Merdeka Belajar, or we know as Independent or Emancipated Learning, as a revolutionary program for Indonesia's education system. In the essence, the concept of Merdeka Belajar is a response to the needs of the education system in the era of Industrial Revolution 4.0 that requires the human resource to have critical thinking and also problem-solving skills, creativity, innovation, communication skill, and also the adequate skill in information and technology related. Therefore, the teacher or lecturer must provide the students with the knowledge, skill, and also experience. So, the transformation of legal education in Indonesia carried out through various methods. One of them is the student learning, center learning, with interactive and reflective methods, which open the spaces for active participation of the student to participate in the learning process. So in the age of digital learning, the legal education also required reliable digital infrastructure and also adequate supporting materials, including the utilization of media, copyrighted materials as the medium to transfer and also articulate the knowledge to a broader audience with various background in the society in a way that that is more easily understood. So the formulation of the application of teaching and learning methods are very important to develop the intellectual ability of the students and also the skill development of the students. Allow me to elaborate the example of the teaching methods. The first is, for example, in my subject, intellectual property. After the lecturer elaborate the relative teaching materials about IP, the students were given the assignment to watch a movie. The movie is entitled Philosophy Coffee or the Coffee Philosophy, and they should report the analysis concerning the intellectual property aspect that they found from that movie. Then the student came out with the different perspective. Some of the students emphasize on copyright aspect of the movie. Some focus on the adaptation of the copyright aspect because the movie is the adaptation from the short story in the novel. Some emphasize of the development of philosophy coffee as a trademark or brand name of the coffee shop in the book and also in the movie, which is later also become the real trademark of highly hyped coffee shop in Jakarta, in Bandung, and also in several other cities in Indonesia. And some are elaborated their point of view from the aspect of local coffee farmer empowerment and also the development of the local coffee culture. Then the lecturer elaborate the intellectual property development, where one of the intellectual product, the short story and the novel in this case, is potentially create other derivative products and also create several income stream and broad positive impact in the development of local business and the community development. In this case, is the local coffee farmers. And we hope through these methods, the student will be encouraged to be more creative, to be more innovative, and also acknowledge the creativity and innovation of the others. After the discussion and feedback, then the students were given the task. They asked to conduct a project of legal education for certain target about the intellectual property subject. We use the interactive learning methods to create a learning condition where the students can learn actively and also having fun in the process, and also create the impact of optimal learning outcomes and achievement. kindly allow me to share some of the outputs of our student project in several subjects in our campus. The first is this webinar, where the students held a free webinar on the importance of copyright protection as the part of legal education. They elaborated that everyone can be a creator, whether they are famous musician or background, or maybe a housewife that loves to write a poetry or stories. So it's important for the creator or the artist from various backgrounds of the society to understand what copyright is, and also to understand how to gain legal protection of copyright for their work or their creation. They also provide the education for the community to acknowledge the copyright of creators and not making any violation or infringement, or not to consume the product of IP violation, for example, the pirated version of the book, the pirate version of movies, and also that. The webinar also trained the students to organize an event and to have a public speaking skills, and also position themselves as the legal educators. Another example is that they upload the legal education content on YouTube. And another example is our student project is a podcast about trademark, where they provide public education on the importance of trademark protection for the business. They also conduct the interview with the micro business owner to raise the awareness of other small businesses to register their brand and trademark. Because in Indonesia, there are many unregistered trademark, especially in micro and small businesses. They also share the public information and also the procedural guidance on how to register a trademark. So this is another example that they made infographic share on their social media. This is the first example where one of our students, Debbie, made an infographic concerning the right of the consumers or about the consumer protection.
Sorry to interrupt. You have less than 2 minutes to conclude your presentation.
Okay, thank you. The reason why she took this subject, because basically everyone in every level of society is a consumer, right? We consume product and also services in our daily life. So it's important for everyone in the society to know their rights and how to defend their rights when needed. She elaborated the right of the consumer and the obligation of the producer and inform about the compliance services in the case of consumer rights violation. So this is for the assessment, we asked them to make a project report or reflective journal, and also we doing peer evaluation. So my point about the student-centered learning is that in the learning process, both the lecturers and the students can provide more innovative ideas and learning from each other if compared to the conservative teaching methods. And also the role of the lecturer is as facilitator with a two-way communication, more interactive. And the teaching process not only to transfer the knowledge, but also to develop the skill of the student and strengthen their community engagement. That's all my presentation for today. Thank you so much for your attention.
Right, thank you very much for Dr. Tisni Santika for sharing some insights from Indonesia, especially the learning experiences. Right, moving forward to the next speakers, we have Dr. Stephen Moniaga. Okay, Dr. Stephen Moniaga is currently the National Coordinator of Indonesian Grassroots Forum, which is known as FARI. They are engaged with non-litigation legal assistance of narcotic cases for several key populations such as LGBTQ and of course adolescents community development engaged since 2005. Dr. Stephen Moniaga is also working on addiction issues as one of the founders of Indonesian Addiction Counselors Association, which is a profession organization for addiction counselors. We welcome Dr. Stephen. Are you here? Are you around?
Okay. Am I audible? Purna?
Yes, you are. The session is yours, Dr. Stephen.
Okay, thank you, moderator.
And if permitted, I wish to just add on here that we need to rearrange the time for each of the remaining presentation And we request that if each of the presenter could conclude their presentation within 7 minutes so that we could conclude the session on time. So it's a request, 7 minutes to all.
7 minutes. Okay. Thank you. It's been an honor for me to join this session. And first, I want to say I'm not a doctor. I'm not academic. Okay. I'm from the community organization starts in since 2005. Okay, so what I want to present today is more be a practical overview to all of you guys. I want to share my presentation, I think.
Dr. Disney, maybe you can end your sharing session first to allow Dr. Stephen to share his presentation. Thank you.
Okay. I think I have a problems in here. Can I just move forward? I think I got a problem with the...
Sure, Doctor.
Okay. Okay. First, I represent FARI, the Forum Akar Rumput Indonesia. We start to move since 2008. We moved in Indonesia. What we do is a building initiative in engaging vulnerable communities. We formed in 2018, need from the assistant narcotic case across the Indonesia, and we start from the social media, and for now we finally existed in the 9 provinces in Indonesia. So, and we network. For now, we join with the governmental institution like Indonesian Witness and Protection Program agencies and UN ODC for the international and IDPC. Okay. The idea from the Forum Akar Rumput Indonesia was based on the move from the narcotic issue, because we start from the drugs policy that can apply to all the drug users in Indonesia. Especially we focus on the high number from the narcotic cases and the bribery system, lack of narcotic assistance from the victim. And we want to be the first aid community and the general public who have the problem with the narcotics policy. For now, start from our small idea. We develop our perspective and movement. So we start to make a community training, disaster response, public educations, and social media campaign. Also, we're targeting the more key population communities such as youth, women's, LGBT, and of course, the more specific issues that we believe that we also have a problem with the justice system. Why we develop our ideas? Because we believe by how to teach the community only if we can ask the community to move together. we believe that if we can build the perspective of the community, so we will get the community more be realized of their needs, and then we will fight for our purpose in every major issue or every key population issue. Okay, for the almost 6.5 years of our movement, we are very self-sufficient organization. We have no donors. We're moving by our own capability to keep on doing. The main reason for this, because as we know that many organizations will find the limitation if we're talking about the donors, and especially if they find amount of money of donors, because we know that donors also have the work plans and everything. So we see there's a limit section for our organization to move. As a civil society perspective, what we learn that most lesson and learn things that we believe that every civil society perspective must be prepared for the challenging, connected to, if you're talking about innovative way to find how to educate about the social justice. I believe that every civil society organization must be prepared for the changing, must be prepared for them to more be adjustable, not just straight to their vision and mission. Because every vision and mission they achieve, they have to do next. That's why me in Fari, in my organization, also always be developed. We're ready for changing, and we always do the explore to see the other key population needs and try to fulfill it. What we, for now, every key population in Indonesia always talk about human rights in every issues, and they're developing in their own way. But we see the cross-cutting, and it's kind of interesting. We find the cross-cutting in it, and we finally developed that. Especially, we finally found the way to approach to get together all the key population to move to sound it, and especially
Dr.
talking
Steven?
about the human rights. Yep.
You have
Am I
another 2
audible?
minutes. Yeah, you're audible. You have another 2 minutes left.
Okay.
To conclude.
Okay. We learned to see that the key factor of the needs in the key population organization, that very, very important, that we must develop our point of view, we must develop our perspective. If we find the breaking point or entry point to move or a movement, we can making a good networking in there. Okay. So I hope by this conclave, I recommend a few things, because this can be contribute for the good human rights education for the public. especially for the youth and the key population, you know. And we have, I hope, we have a more frequent meeting and more technical working group, whatever can we do, because human rights for now, especially in Indonesia, is very highly recommend in every programs in which is in exist. Yeah. I hope that all the members in here, I strongly believe that all the members in here have a many experience and many knowledge to develop all of the issues and all of the technique to and willing to give implementation program with us. Okay, I think that's it for me.
All right, thank you very much for your insights, Dr. Stephen Muriaga. All right, the session will move to the next speakers. Ms. Ragini. Yeah, Ms. Ragini Ahuja. She's a director clinics at NLSIU and leads experiential learning program at the law school, where she's developing a more clinical curriculum that is based on the intersection of academic and practice. Prior joining, I believe that is one of the National Law School. Ms. Ragini was litigating for close to a decade. The area of litigation includes defending people on a death row, civil liberties cases, custodial violence, and other issues related to condition and in-kind coercion. Welcome you, Ms. Ragini. The floor is yours. Ms. Ragini,
thank you. Yes, I'm here. Thank you. Thank you for the introduction. I know we're short on time, so I'm going to try and wrap up quickly. And we've already had some very wonderful output from everybody, so I'll try not to be repetitive. I want to begin by saying that I'm very new to the world of academia because for the last 10 years, I've been a practicing lawyer with a largely pro bono death sentence practice. So this is my transition into academics. So for today, what I thought I would do is just go over some of my reflections and observations in making this transition from practice to academics and in trying to understand how to incorporate themes of justice in clinical education, which is what my role primarily entails. So interestingly, if you ask a law student what the meaning of social justice is, you're actually likely to get a very different answer from what I think some of us imagine it to be. And this is not their fault. It's because in a traditional academic setting and the manner in which law is taught, at least in India, law students have not been exposed to either the actualization of social justice or its denial in the manner in which it pans out in reality. And so to that sense, I think that we have a very long way to go in exposing them to this. And I think social justice is not key just because we're talking about the law. I think this is also about how we want to foresee students as future citizens, irrespective really of the stream of study that they're pursuing. In the Indian context, we've been speaking of social justice in legal curriculums for very long, but I think we'll all agree that we haven't really seen much of a transformation. And I think that that's because, at least with Indian legal academia, I feel like we haven't dirtied our hands enough. And so generally speaking in India, students and legal curriculum are for the most part innocent of many aspects of the practice of law. So traditionally in India, law would be perhaps divided into two ways in which we would teach it in a traditional classroom setting where you learn the theoretical aspects of the law, and then in a more practical setting that's divorced from the classroom through traditional internships, which are mandated by the Bar Council of India, where you expect them to glean the aspects of the practice of law. But what's happening is that because these are so divorced and they don't come together often, I think that students aren't able to effectively identify gaps in the law, as well as develop strategies and thinking around what social justice really should be. So our key focus has been to see if we can bring academics and practice together in a manner where we make the curriculum more clinical, more experiential, where students get to experience both together and where they're not completely segregated by way of study. And so we're focusing on experiential learning in a big way. We're making an effort to get practice and legal education together so that we can expose students and get them to understand what social justice is, not just in the classroom, but also outside. And to do this through giving them exposure to understanding issues of marginalization. So marginalized exposure to marginalized communities and exposure to marginalized regions. This is how I would see it play together. And we're making a very big emphasis on this. In India, we have certain constraints, meaning that a lot of practitioners don't enter academics and a lot of academics don't practice. This is because we have some constraints and rules that the Bar Council of India has. And so I think we're uniquely situated in a way where we have to understand how to develop this kind of curriculum working within these constraints, and how to work on it in a manner where we build on the existing networks. So just to quickly take you through some of the ways that I think we're looking. Sorry, I think there's an echo or someone's mic is on. Sorry. So just want to quickly run you through some of the ways that we imagine doing this at NLS. The first is through an externship program. This is something that Professor Margaret mentioned as well. And I think at NLS in India, we're amongst the first law schools to do an externship program for public interest law, where we want to place students who work with public interest lawyers and get academic credit for it. I think this is a concept that's very new to Indian legal curriculum, where we award academic credit for more practice-oriented courses. And so we're developing an externship program for public interest lawyers who get support from students at National Law School, Bangalore, and students in return get academic credit. This is supposed to be a program that spans the length of the trimester, and therefore, in that sense, would be a more sustained engagement than a traditional internship program. Here, I want to emphasize something which I think Dr. Vani also alluded to, which is that we have students very often wanting to be in fancy positions. And if you ask Indian students who want to litigate, they want to be Supreme Court lawyers. And I feel like we have absolutely no emphasis on the lower courts and the trial courts. So here at NLS, we're trying to develop an externship program where we place students with lawyers who work with trial courts, which are, as KG Kannabiran said, the first line of defense. These are the most important courts, in my opinion, also the courts that actually require the most amount of assistance, particularly student assistance. And I think we would all be aligned on this. So I think as law schools, we need to emphasize the importance of courts of first instance, not just in the classroom setting, but also in terms of placing students to work in these courts, whether it's magistrates courts or sessions courts or any other court of first instance, a consumer court, where students really see how the law operates on the ground. Because the Supreme Court is a very far off court. It's accessible to a very small percentage of citizens in the country. And our students are disproportionately interested in working with the court that does the least number of cases in the country. No doubt they're of constitutional significance, but if you really look at the proportion and the manner in which cases are litigated, and I'm sure this applies for every country, I think our emphasis in law schools on lower courts is disproportionately lower to the contribution that they make to jurisprudence. So the externship program would be one. The second is a legal aid clinic that we have at National Law School, where we're now trying to shift the focus from content intervention to strategic intervention. And this is also something Dr. Vani spoke of, where he said, legal literacy plays or plays that legal aid societies do aren't really the way to go when you want students to engage with issues of social justice. And I agree. And I think that the reason why a lot of legal aid clinics at law schools intervene and do content intervention, where they do legal literacy workshops or they do legal aid plays, is because these legal aid clinics are not held by practitioners, but by faculty who have perhaps not practiced in courts, and therefore can only push the boundaries. So there is a certain importance of academic rigor, and I appreciate that. But I think with something like a legal aid clinic, we need to make it more practice oriented, and we need to work in ways where students work on strategic interventions with communities over and above any other kind of legal literacy they may do. So that's our second focus, which we're looking at doing in a very big way. The third is to offer clinical electives. I think this is one of the easier things to do, where you get practitioners to come and teach courses at law schools. And this is how you facilitate real world interaction between practitioners and students. And really, these clinical electives could be any field of law. And I agree with Dr. Meenu when she said, commercial law is also important. And you would have an element of justice in tax, in commercial law, in arbitration, in so many things. And therefore, clinical electives of any nature, I think, add a lot of value litigation-based, of course, practice-based, of course, but even corporate, commercial, clinical electives add a lot of value. And I think that we need to recognize the value add that practitioners bring and find ways of making it easy for practitioners to contribute to the academic setting in India. The fourth is that at NLS, we have now made it mandatory for students to, and I think some others also spoke about this, to intern with NGOs where they only work on social change. The purpose of this internship is not even any legal learning. We want to start with the basics. What do law students understand about empathy? How do they relate with grassroots issues? What kind of sensitivity do you want a law student to invest in their own practice, no matter what the nature of that practice may be? It could be a commercial practice, but if you expose young students to grassroots issues and issues of marginalization early on, they're more likely to be invested in the practice of law in general, no matter what stream they eventually choose to practice in. And so I think internships which are even devoid of legal components, but address issues of social change, of social justice, of social transformation, that show students the power of collective mobilization, of thinking on the ground, of how communities come together. I think there's a great value add in this, and perhaps this is something we should push for more. And I was very happy to hear that Dr. Meenu spoke of this as well. The fifth thing we're trying to do is to devote one entire day every week just to experiential learning, so that students will be off campus. This could mean that they are out in the field collecting data. This could mean that they are interviewing prisoners in jail. This could mean that they are mediating workers' disputes. But the idea is that they step out of campus, and what they've learned in the classroom, they see the manner in which it actually pans out on the ground and the way in which it plays out on the ground. The last thing I would like to mention before I wrap up is that my observation has been, and this applies to me, so I don't know if it applies to anybody else, but it certainly applies to me. I think we have been resistant to technology and the introduction of technological advancements. Maybe for me, it's because I just don't understand technology well enough. And so my first idea is to resist when new technology comes in. But I think that we have to find ways of capitalizing advances in new technology and work towards student benefits for that. So I think we could have never imagined a situation where you were arguing remotely, where there was a case in the Supreme Court of India, but you were arguing from your home. And I think that what that's taught us is that there are more models to work on that allow for student engagement beyond being present physically on the ground. And no doubt that has its own importance. But I think that when we think of social justice, we need to also expand our own avenues of what kinds of interventions we can make. So these have been my broad observations and learnings. I'll stop here so that we can carry on the discussion with everybody. Thanks.
Thank you very much, Dr. Ragini, for this wonderful presentation. And I wish to thank you for also connecting your presentation, the points which you discussed with other presenters' presentation. We are running short of time, so you gave a kind of concluding remark by referring to others' presentation. So you have, in a way, helped us out. Now we have a last presenter for the session. She is Ms. Puthe, and I request her to kindly start her presentation, and as we have limited time, so I most humbly request to conclude in 5 minutes.
You hear me?
Yes, we can hear you.
Okay. Did you see my slide?
We can see you. Seems you are in the process of sharing your screen, but we have not yet seen. We have not yet
seen the screen. Okay. Without further delay, because we have a very short time constraint. So first of all, I just would like to introduce myself. My name is Puthe. I currently teaching at Panyasastra University of Cambodia. Okay, actually, I have different field of teaching. Example, the dispute organizational communication and dispute resolutions, and as well as the gender study and some part of my teaching with the gender and human rights. Okay, I mean women and human rights. So I've been working at Panyasastra since 2011. It's quite a long year of teaching. So I hopefully that with my experience and the contact in Cambodia, especially at Penyasastra University, would contribute to all participants today's. So allow me to just share you my presentation. Actually, have you seen my screen? Cannot? Oh, no
We can see your screen, but your presentation is not there.
Not yet.
Yeah, it's visible now. If you could.
So,
yes.
Visible. Okay. All right. Good. So I make it short because I create a very long presentation, but anyway, would come out with a very short because we have time limited. Okay. Oh my gosh, what's that? I think, okay, yes. So my objective of this presentation, we would like to share you the section on the effective teaching methods and assessment for social justice. Okay. So briefing with this, and I have an objective of this one. We would like you to understand us about the understanding of technical teachings as well as the learn multiple purpose of teaching assessment accomplishment. So at this point, I just would like to say that as a teacher, you may know that there are tremendous things that we need and passionate to let the student learning. And the challenges as a teachers, we would say that because teacher have different, student have different behaviors. So then how approach in social justice to make sure that in terms of gender study, like my experience, in terms of how we teach human rights and human rights in the context as a way to make sure that students would be able to understand our contents and stuff. So to brief, okay, I would move on into the other ones right here. Okay, so the key points that I think I have listened to different participants as well as presenters focus on different ways of how approach that can be helpful for student learning. But at this point in my own experience and theoretical, we have already know that how would we know to succeed. So as a teacher, of course, we have a skill and we need to find assessment and learning. Through that, I would move on into this one. Okay. Here. So to access student learning result, we need to have some goal-oriented, okay, and as for experience with learning process and tend to relate it to the new and old. So as we can see that in the Cambodian context, when we focus on the social justice in teaching, it's a bit sensitive sometimes, okay, because of different party might view different way. So the approach for teacher need to be very smart and good. Otherwise, it's gonna be the other party might, especially government, might view in the wrong way. So that is one of the more challenges for us as the teacher. So at this point, through my own experience, okay, so to avoid those type of challenges, we try to make it clear and objective how we can approach the student to learn, okay, and why the teacher need to do assessment. Another one, we want to know that how the assessment is supposed to be. So the assessment that we need to know is that we need to make sure that student preparedness for further studies and professional accreditations, okay, rank student relative on the others, and purpose of the competitive scholarship and opportunities. So this is assessment that we want. So our passion is not only in class, but we want the student to engage international workshop, a short international workshop. So that way the student would be able to open their minds up and learn further. So move on into that, we would provide the feedback later on. So I think I would move on to, okay, this one, sorry, very short. So why feedback is important for the teachers and towards student learning. So as a teacher, if you teach without feedback, student would not know how much they learn. So that's why as a teacher, you need to help the student to reflect their learnings and how approach is supposed to be, and identify the area that need to improve the student learning. Another one, and begin with the make an improvement. I think I make the source inside of that. Okay, and move on to the other slides. Okay, okay, here, that is the key point. How to teach your social justice law college initiative. To me personally, I think we should raise the concern case study in class after we teach theories and everything different law. And example, we focus on equal economic, politics, and social right, as well as the other opportunity for the student in the social context, okay, in the current social context. So then later on, we would let the student to work as a group for student to provoke the consequence of key pillars in terms of social justice, example, equal rights, equal opportunities, okay, and as well as the equal treatment. So at this point, we can mainstream the student to learn not only in theoretical base, but we want the student to understand the practical and reality. If they will be the lawmakers, what would you do? Okay, so the other one, we focus on the engagement of the fieldwork study in explore the actual situation in society and how students will be able to contribute and back to society in the future. To me, at Panjang Sastra University, of course, we have a PhD legal clinic. So the PhD legal clinic we will provide for undergrad students. So undergrad students not only learn in class, but they can take this course, okay, in the fieldwork. So that way they would understand the situation. We might teach, we would going to teach like children rights or any related rights that could give them understanding more. That's one point. So like my own experience when I teach in the human rights and women rights, okay, we would let the student to do a case study in the companies, okay, which focus on the discrimination at the workplace in terms of the gender balance between male and female and any other related law, which can help the student to explore that how it would be and how it met and how we would change on that particular things. And in another university, as I have engaged with the Royal University of Phnom Penh, I think rule we call rule. Royal University, Rule. I think the law school and in Phnom Penh University, they have a moot courts. Okay, so moot court we have competing with different area in the Southeast Asia. So that way the student will feel more competent. And I heard my friend already mentioned on the they let them practice and they let them go and to see the parliamentaries. So this way it helped the student to just not only in class session, but it could help them to inspire them and learn more in the practical ways. So at this point, you can see that in the way of how you strengthen the student, it's really important that you cannot not only just mainstream the learning in class session, but also especially the fieldwork. I can feel that when we do the fieldwork, the student feel like they kind of like it a lot. And PUC have collaborative with different NGO so that we can just tackle all the things to make sure that student would be able to learn outside of the class. I think out of the campus is one of the significant. So if we can do that way, and also I myself have used to teach, I feel like, yes, it's flourished like the flowers. Okay, it helped them grow themselves a lot. And also, I think I would end of the class, end of the presentation today. Thank you. Yes, hopefully we'll not run out of time. Yes.
Bharti, please unmute yourself. Bharti.
Yeah, thanks, Uchula ma'am. So Dr. Puthe, thanks for the wonderful presentation. And I really appreciate your time management. And you share your innovative ideas for promoting justice education. As all the presentation for the day has been done, so we have come to a point where we are about to conclude today's session with the wonderful knowledge and experience which we have gained through various presentations which are not from India, but also from other parts of the world. And through this knowledge sharing, I'm sure that we all have gained some innovative ideas to start a new beginning of spreading justice education and how we can inculcate it in our teaching pedagogy and all. So I wish to thank all the presenter, and I request my co-moderator and the chair if they have any concluding remarks, and also the Ujjwala ma'am.
Thank you, Valti. I think this was a wonderful presentation from all of you. I do have a lot of questions and comments to make, but there are time constraints. Maybe, sometimes we can share our experiences and questions and comments and reflections personally on the email or WhatsApp group. So thank you all for being present, and let's break for 10 minutes and then we join again for another session on panel discussion. Yes.
Ujjwala ma'am, I see one hand raised from one of the participants.
Yeah, let me just check. Yes, Dr. Samuel, you can.
Okay, thank you very much. The presentations have been so wonderful and insightful and revealing. So many things are coming up, and very practical approaches to delivery of justice education. I want to ask, can we have access to some of these materials from the presenters? The presentation is going to be made available. Would there be a platform through which we can access the presentations from all the participants, where we can download them possibly and get some of the materials?
Dr. Samuel, it seems organizers are trying to work out on this, and you will be informed via email if the presentation means the PPT, which has been used by all the presenters, which gives a complete picture, a kind of screenshot of the knowledge and experience which we have gained today. And I'm sure that those PPTs can actually give us a backup study material to build our knowledge and understanding. So the organizer will contact all the presenters in case they wish to share the presentation. It will be shared with you and other presenters interested. And now Ujjwala ma'am would like to add to it.
Yeah, just to add to what you said, we generally prepare a report of the entire conclave, and there we include the presenters and the participants and their views and what they really presented. So it is published in the form of a booklet. We'll be sharing with all of you that booklet. Thank you.
Thank you very much.
Thank you, madam. Thank you. Thank you, everyone.
Thank you, everyone. We have a break for 10 minutes and we join again. Thank you all. Thank you so much.
Thank you so much.
11:40 we are joining again.
Sure.
Yeah, after 10 minutes we join again. Thank you, everyone. Thank you, Margaret.
Thank you, ma'am.
Thank you, sir.
Thank you, ma'am.
Hello, Bruce. Good morning. Somebody has joined from Bruce Lasky's. Bruce Lasky, are you there?
I am. Hey there.
Hi, Bruce. How are you?
Hey there. Good, good. Greetings from Laos.
Good morning.
Great to good morning. Yeah. Good afternoon here. Just a little bit. Yeah, fantastic to see everyone, if only virtually. Wonderful.
We just completed the presentation session 5, and in the next session, we are going to have a panel discussion.
Right. Yeah. I saw that. I've had things on all day.
Earlier session was really nice, very well
Was it good?
presented, Bruce. I'm very happy with the earlier session.
Fantastic. And what and the participant turnout? How has that been?
Bruce, Lenny is signaling something, so I don't know what is she
I
saying.
don't know.
I'm sorry, she's signaling me, who just jumped on. Hi.
Okay, hi.
There's Wendy. Wendy's in Thailand
Well,
right
session
now.
5, we had presenters from USA, then also from Cambodia, from Indonesia, and from India. So it was a very insightful presentation, in fact, I would say.
Fantastic. Who did you have from Cambodia?
Yeah, we did have one from Cambodia.
And who was that from Cambodia?
Sorry?
Who from Cambodia was?
Puti said. Puti said. Puti was there from Cambodia.
Okay, great. Excellent. Wendy and I we just were in Cambodia last week. So it's great to see things continuing to move forward there.
But I'm very happy, Bruce, this time because I could get presenters from, from countries where I was not expecting to get response. So I have participants like from Pakistan, from Saudi Arabia, from Cambodia. So I'm very happy. So
really well done. Really well done.
We get to know, what's happening there. But again, as I said in the last conclave to you, and I have a request to make to the regional committee, if we could have, last conclave as a teachers training program, that would be really helpful. Or maybe, some students can also join that. That will be really nice. Instead of,
I think to add that on as with a TOT, I think is really great. I think that it's
So
I think
maybe
that
I will send an email to you, to the regional committee, and requesting if we could, and the last one, if we can have a TOT. So I think that would be very helpful.
Yeah, really brilliant. Fantastic.
Yeah.
We're now in the process, we're organizing the second Asia Clinical Legal Education Conference, I think, at the end of May, and that will be in Chiang Mai. And there'll likely be various TOTs. And so that's broader than the regional conclave and kind of builds on much of the work we've been doing in the region for probably more than 20 years. So we're excited about that, and it's it's really important to have these regional sort of broad regional convenings happening, as we know. In addition to the global stuff that Gage is doing, we really see the need to yearly plus have these more regional focused gatherings, both for sharing and also for the trainings, as you pointed out. So it's great to see all this moving forward.
Mm-hmm. Yeah.
And Lenny, how you doing down there?
Hi, I'm doing good. I'm just running out of coffee and I need more wine.
Excellent. Fantastic. Yes, I have my cup here, so I'm in solidarity with you.
You know, I hope I can be joined on May, even though that maybe I might not be presented, but I just want to go to Chiang Mai and meet you all.
Of course. I know Irma. I thought everybody's Irma, but Irma, like the original Irma, also says, no, we'd love to get you up. I mean, we'd love for you to get up because it's been so long since, and because we're not as much based in Chiang Mai anymore. To have events in Chiang Mai will not happen nearly as much. We're shifting, but this gives the opportunity to have it in Chiang Mai. And May's a good time to do it. So it'd be great to have you to get up there.
Yes.
And we'll have coffee there.
Yes. And then Uncle Coffee. Is that true?
We can have coffee there. Yes. And good Thai. Thailand has good northern coffee. So even, but that's definitely moving forward. And we're having meetings with Chiang Mai University this week about it, just to kind of finalize on some of the many details. But it'll be great, and you know how it is. Doing the in-person hybrid thing will be fantastic. So you can get up, wunderbar.
Yes, it's always been my second home or something because I have friends there, and then I can go. I love my times in Chiang Mai.
Absolutely, and actually, Wendy's there right now. She's at, I'm in Laos,
and I love times in Chiang Mai too. Since I'm here. No, it should be really great. Yeah, gosh. Yeah, it'd be like a big homecoming for so many people, everyone just
I feel like
our regional brothers and sisters and uncles and aunties.
Exactly. It's like extended family to me.
Yeah, same.
Yeah.
Same. Okay, I'm going to hide myself as I'm not one of the important presenters.
I think Anne is presenting in this next session. So she actually will be one of the more important presenters from Thailand. So yes, excellent. So wonderful. All right, yeah, I'm just gonna turn off my camera for a bit and just wait for it to start, okay?
Okay, me too.
And I gotta feed my cat. He just came in the window.
Right.
Hi, Rennie.
Hi, Anne. Good to see you again.
Good to see you.
Look at you, Mrs. Lawyer. So how's everything in Chiang Mai?
Good. Yeah. Can't wait to see you in May.
Yeah, I miss everybody. So the night market's still there?
Yeah. After COVID, now everything is kind of getting back.
Yes. And what is it? Well, used to be the faculty has a plan to go to Thailand, but I don't know, the plan was postponed because it will be nice if we can go to Thailand, right? And I can meet friends in Thailand. But yeah, things got changed. But I try to go in May. Hopefully everything running smoothly.
So, good afternoon, everyone. Welcome again.
Good afternoon. Good afternoon.
Yeah, so I request Professor Devinder Singh and Leni Vidhi to start with the session. Yeah. Please start with the session now.
Yes, we have decided Dr. Leni Vidhi will start, if she's here.
Yes, yes, I'm here. Okay. Thank you so much for the opportunity, Dr. Ujwala and Professor Devendra Singh. So, ladies and gentlemen, right now we are moving to session 6, which is the title of session 6 is the role of the law school in teaching of legal ethics and professional responsibilities. And there will be around 5 speakers, and then this session will be facilitating by me and also Professor Devendra Singh. And we already have a communication beforehand. So probably Professor Devendra Singh, would you like to introduce yourself?
Thank you, Leni Vidhi. Very good afternoon to everyone. And once again, I'm thankful to be the part of this session. I welcome you all in this session, the role of law schools in the teaching of legal ethics and professional responsibility. I welcome the coordinators, the panelists, and hope that the deliberations and presentations would be very fruitful for all of us for taking the legal education ahead. As far as professional responsibility and legal ethics are concerned, we all understand that we are working in such an system where law schools are apart and legal professions, the courts are apart. And what is our endeavor, what is our drive to connect them both? At times, certain efforts has been made, but ultimately we reach that how to connect the both, the law school and the courts, where actually the profession is being practiced. As we see in medical profession, they are collective. Medical college and medical hospital, they are collective. So students are learning medical techniques during their studies. But here, the only connectivity for us is through legal aid clinics, etc. Therefore, what is expected in the present system, specifically in India, that Bar Council controls the education, and we see if we see this ethics, legal ethics, or professional responsibility, that pertains to the court, the judge, the lawyer, and the witness and the parties. It is for them. Therefore, the best practices in the courts, by the judges, by the lawyers, by the parties, by the witness, if there are certain best practices, then we must have a relationship of law schools with the courts, with the judges, with the lawyers, and all parties and witnesses. So best practices should be taught to our students. The Bar Council of India in this territory of India, they have made this one of the paper compulsory, one of relating to this professional responsibility and legal ethics. Therefore, that should be done by the professionals only, by the judges, by the lawyers, and if we find certain things which are the good experience of our witnesses or parties in the court, they must visit the department law schools, and they should share the experiences among the students. So when they become lawyer, they should have something in their mind that this is best, this is good, and this is not good in the profession, and they will adapt themselves in the profession as such. With these few opening lines, I wish all the best to the panelists. Once again, welcome them and request Leni Bidi again to introduce the panelists and so that there could be some presentation through which we can all learn. Thank you very much. Over to Dr. Leni Bidi, please.
Okay, thank you so much, Professor, for the beautiful insight. So without further ado, I would like to request the first speaker. His name is Rosa Tejabuana. So Reza Tejabuana, he is a lecturer at the Faculty of Law Pasundan University, a member of the Association of Indonesian Legal Philosophers, and then he also a licensed lawyer, experienced in legal aid activities as a public defender. And then his research interests include philosophy of law, fundamental problems of law, especially in the relationship between law, logic, and ethics, international law, air, and space law. So since undergraduate students at the Faculty of Law Pasundan University, he engaged in CLE activities, which is actually, he is our first graduate from CLE program since 2007. So, and then he and his colleague are developing a more sustainable program for CLE courses, such as integrating CLE into the mandatory curriculum, international programs, and annual recruitment for students volunteers. And Rosa also received the bachelor degree from Pasundan University and master degree from Pajajaran University. Okay, so to Mr. Rosa Tejabuana, the floor is yours. You have 10 minutes to present.
Thank you, Miss Leni. You can hear my voice, right? Good afternoon, all of you, everybody, professors, sirs, and madam. Thank you, Miss Leni, for kind introduction, and I would like also to say hello to fellow panelists in this session, Dr. Folake, and then Nafaraj, Dr. Barati, and Anne. Hello, Anne. Okay. And actually, I sit next to Leni in the same room, at the same university as Leni mentioned before. Thank you for this opportunity. And I would like to share some activities which we have been conducted here in Pasundan University, Indonesia, Bandung. In the past 2 years, and what will we do next in the future. So I would like to start from, as maybe a fellow presenter from Pasundan University from the last session from our student mentioned about how we engage in clinical legal education. We managed to sustain the strict law program. So our clinical legal education is focused in send and provide our students with experience to educate people, especially marginalized people in rural area, in some minority community, to give them information. If I won't say give education, to make this group informed about their rights, and maybe they can help to provide answer if this group find any difficulties when dealing with local authorities or with other people, or maybe they have a personal case or with their family. But in the scope of legal education, so our CLE do not develop hard skill for lawyers, such as how to manage yourself in courtroom situation. That's in another clinic at our faculty. There we have also legal clinic, yes, aside from clinical legal education, which develop lawyering skill for our students to become future lawyer. Street law program. So our student, as I said earlier, develop soft skill such as communication skill, teamwork skill, and then what I want to bring what I want to share today is how our clinical legal education try to bring empathy from to our students because of their engagement, because of their socialization directly with the community, with the people. So it can be understand that during the COVID-19 pandemic, our goal is a little bit hard to achieve, because the social distancing and some government policy that prohibit group activities and close engagement, and the faculty and the campus and our university, of course, must alter to virtual learning. So it can be a challenge to all of us, of course. How do we still manage to teach this social trait, social justice trait to our students without they are able to directly communicate with people in the way that they have to previously from the past learning? So we have to think a way, now, but why in the first place that we try to develop the empathy? You see, our students in the future, maybe they'll be a judge, lawyer, or prosecutor. They're dealing with people, with person, with a person with instead of aside for rational thinking, but also having emotion and having attitude and maybe some gesture. Some are nice, or others are not too nice. But so we think that to give our student direct experience in communicate with these kind of people, it will make them ready if they should engage with them, interact with them in a real life situation. So that's what we are trying to develop in our CLE. And I am following the footstep of Miss Lenny as the coordinator of the CLE. So our program, if we want to say, successfully bring this kind of emotion and empathy, because when our students not only learn in class with their fellow colleagues and teacher, but also engage with community in the community, as they will experience how this community live, maybe how they work hardly, and how their economic situation, how about their educational level, which are different from them, either with the elderly or the student from high school or junior high school, and with several other community. This will expose our student to the reality of the situation about a kind of social injustice among our society. So maybe this will help to trigger the empathy and the willingness in the future for them to advocate the rights of this community, these people, which also for time to time marginalized in society. And maybe I don't know about the experience in other country, but in Indonesia, especially in Bandung, the information or access to justice, even the basic things, basic information about how the court work is not accessible almost to everybody. I mean, it's not like there is no information about it, but legal norms and legal process must be interpreted, because we sometimes use terminology and some kind of unusual word, not daily term for daily conversation. So our students is helped to become bridge within this legal system and provide information to be simplified to the community in which our student engage.
Sorry,
with.
Rasa, to interrupt. You have 2 minutes left.
Okay, in the last 2 minutes, I will show you what the project our student currently doing. Maybe I would share this picture. Maybe you can see. Okay, this is the virtual reality device developed by our student. This is the person on the left is our fellow researcher, and the boy here is our community. This is at high school, if I'm not mistaken. So we introduce courtroom situation through virtual reality. So people can understand more in a way they are felt to be involved in the situation, like in a simulation. So this is what our student brought to the community, and then what actually did these people see in the situation. So if you can watch my see my screen, so this is actually what they see. They say there will be dots, and the dots will provide information. This is in Bahasa Indonesia, and this student and the user can scroll in 360 degree to see the courtroom. This is the one example with still image. It's only just to who are these people, who are these people, who are these men, and there will be information about it. And there is another kind of situational, more is the video. This one is a video. So the user of the virtual reality device can see the entire courtroom within entirety. So why do I brought this this issue to all of you? Because for us to be able to teach others.
Sorry, Mr. Rosa, I think I should stop you because the time is over right now. Thank you anyway. But we will talk a little, about this a little bit further, because these sessions is quite different from any other sessions. And then there will be a questions to you. But we have discussed earlier with Professor Devinder that the questions will be from us, and then the question will be asked after all the panelists deliver their presentation. Thank you so much for wonderful presentation, Mr. Rosa Tejabuana. And then I also have a communication from Ujwala, so maybe for the next presenter, it should be a little bit more focused to legal ethics, and then we can move on to questions and answer after all the panelists. Okay, so I call the second presenter, which is Dr. Bharti Yadav. By the way, congratulations for your new position in GAGE. So happy to be a part of this again. So Dr. Bharti, she is from the National Law University of Delhi since 2012. And then she organized many international and national workshops and conferences on criminal law and clinical legal education at National Law University. And her research papers are published in many journals and books. And she also supervised a number of LM students and their dissertation. She has been a resource person at Haryana Institute of Public Administration in various training programs for HCA officers and law officers in Haryana. Since 2015, she has been continuously appointed as an external member of Complaint Committee Against Sexual Harassment at Workplace. And then she has presided session on promoting justice education in international conferences, where I met her in person at the Global Alliance for Justice Education in Turkey in the year 2015 and Mexico in 2017. Without further ado, to Dr. Bharti Yadav, the floor is yours.
Thank you very much, Lenny. I think it's the second time when we are contributing in a session to make it more meaningful as far as possible and as far as we can contribute. So it's wonderful meeting you again in the regional conclave for promoting justice education. So as the theme of the session is like how legal education can promote ethics and professional responsibilities among students. So I wish to begin about my understanding about the education. I strongly believe that education is a noble profession, and teachers inculcate this sense of responsibility among the students. And when we say our youth are the future of our country tomorrow, then it's the teacher who contribute in shaping the future of our country, because it's the teacher who teach them knowledge, who teach them their responsibility, the ethical aspect of the knowledge which they are imparting to them. So teaching is something which contributes in shaping the future of any country. And when it comes to legal profession, the responsibility associated with teaching of law is much more, because law is a field which touches upon the very sensitive aspect of each person. Law regulates human behavior. Law regulates to restore the faith of people whose rights have been violated. So when a teacher of the law teaches students the knowledge, it's his responsibility doesn't end there. It extends to imparting the skill to practice law, and which include in itself the ethical practices, the moral obligation which comes with it. Sometimes it happens that the focus of teaching of law gets theoretical centric, and sometimes the incorporation of skill, knowledge, and understanding takes a back seat, and that could have a detrimental effect on the time to come and the role the student can play when he actually start practicing law. 11 years ago, when I started my career as a teacher of law, I was fortunate to get to work with those people whose vision about social justice and legal education and what responsibility does it carries with it was very clear. I got to learn from them. Then when I step into the class, I should not only teach them the theoretical aspect, which is indeed very essential, very important, because it lays down a strong foundation, but to stand with stability on that platform of legal knowledge, we need to inculcate a sense of ethics and social responsibility in the students. And that can be facilitated through the clinical courses, through the ethical courses. And I'm very much in agreement with the point which Dr. Devendra made at the opening of the session, that is the skill can better be taught, understood by people who are practicing law. And India, legal academia have this drawback of not being able to practice once they step into full program of teaching. So I am completely in agreement with Dr. Devendra's suggestion that these courses can better be taught with collaboration. And I wish to emphasize that when we have acknowledged this fact that we need to have collaboration with the Bar Association, Legal Services Authorities, and other agencies and institutions which are working in the field of promoting access to justice, we should also understand that how that collaboration can be facilitated. That collaboration also has an element of ethics to it. When I started teaching law and tried to add clinical component in all the subjects which I taught, so that all the subjects which I taught are never understood in segregation or devoid of the ethical responsibility which it carries with it. So be it a research methodology, be it legal method, be it criminal law, any subject which I have taught in the last 10 years, I always had a clinical component to it, along with the mainstream clinical courses which have been recommended by the Bar Council of India. So this could be one of the practice which other law schools and other law teachers who are in this field of promoting legal education in general and promoting social justice education particularly can try in their respective jurisdiction and in courses. Second practice which I adopted was to collaborate. I worked for the prisoners. For that, I collaborated with Delhi Legal Services Authority and Delhi Prison. And that collaboration came by our rapport with them, and that could be promoted and developed and fostered through the ethical norms which we always kept intact. Ethics and confidentiality. That if we are getting to speak with a prisoner, we need to take care of the ethics which are required for interviewing our prisoners. We need to maintain the confidentiality of the official records, which can be presented before the court, but not anywhere else. And the best way of learning ethics or any skill is through experiential learning. Students learn better in the environment from which they can imbibe the need, the relevance, and the consequence of following the ethical practices. I always engage them experiential learning and to supervise them, because I understand them that they are young, they can get sometimes enthusiastic about something, and they may underestimate the responsibility of confidentiality and self-restraint. So I always walked with them step by step. So that's the third practice, that if you wish to excel in promoting justice education, your work, your responsibility is more than a teacher who is teaching just only a theoretical subject, which doesn't have a clinical component. Because classroom teaching is over when you teach in the class, whereas clinical teaching never gets over. When you take your students to experiential learning, you need to stand next to them, keep on telling them that this is how you should speak with people. This is how you deal with people. This is how you deal with the emotions of people, which is something which is not written in the law books. Because when we were working for the prisoners, the people were so depressed in the jails. They were looking for their chance to represent their case strongly before the court, though they were getting legal aid, but some of them were not satisfied. So sometimes students also experience the outburst of emotions, and then how to deal, how to respond, not react to that reaction of emotion is something which need to be taught to students by a teacher who is dealing with clinical courses and ethical courses, that how you should respond, how a student should respond to the ethical response or reaction to the person whom you're responding. That was another aspect of my practice of dealing with this course of clinical legal education, and inculcating and teaching the skill of ethical practice and social responsibility in the students. As I said, that we always tried working in collaboration with different agencies, different government organizations. So we always took care of following the norms, of working with the institutions and the protocol which need to be followed, and how the reports needs to be submitted and whom it needs to be submitted. We always followed a proper channel with it, and that's why we never felt any difficulty in receiving the cooperation which is needed. Because when I say the best way to teach ethics and social response and professional responsibility is through experiential learning, and for experiential learning we need to have access to different institution, be it court, be it police station, be it prison, or any other institution. So for them, first of all, a teacher owes a responsibility of teaching its students the code of conduct.
Bharti, you have 2 minutes left.
Okay, thank you for reminding. And last but not the least, when I set up a pro bono club at my law school. In addition to working in the urban area, we opted to work in the rural area also. We adopted a village. I took my students to village so that they should learn about the diversity of our country. We say India lives in its villages. So the students who are living in a big city should also know the kind of concerns villagers have and how it needs to be responded. And for them, they also need to understand the culture, because the responses and the way and the manner in which a student who is a future advocate deals with the concerns actually makes a difference in his success when he take up this profession of law as a full mainstream work. The last point which I wish to add here is that one of the practice which can be adopted by the teachers for promoting ethics and professional responsibility is this, that we all understand and knowledge that it requires resources, infrastructure, finances to have this experiential learning and promote education, which is different from the mainstream education, and all the institution may not have that resources. So the institution which has resources may come up with online courses like we did. I have an online course on access to justice. It's a MOOCs course, which we again developed with in collaboration with UGC and Ministry of Education, which is available for free to everyone. So these are some of the practices which I adopted for inculcating the sense of ethics and social responsibility while teaching all the theoretical courses which I taught, along with the clinical courses and the pro bono club which I have. And the concluding point is collaborate. And when we aim at teaching our students responsibility ethics, first of all, we teacher ourselves has to exhibit a high standard of ethics and responsibility, because we are the inspiration for our teachers. Thank you.
Thank you so much, Dr. Bharti, for your wonderful presentation. And it's really important to do such things like that, especially for the students. Okay, for the next speaker, I would like to call Folake Tafita, PhD. Are you there, Ms. Tafita?
Yes, I'm here. Thank you.
So her name is Folake. I hope I say it right. I'm sorry if I said wrong.
Very well. Very well.
Okay, Folake Tafita, PhD, is the Dean, College of Law, Christian University, Abeokuta, Nigeria, a senior lecturer with expertise in health law, human rights, and international humanitarian law and clinical legal education. She is graduate from University of Toronto, Canada, and fellow MacArthur Fellowship in Reproductive and Sexual Health Law. So Folake is a trained nurse. Wow. Prior to her legal education, she obtained a diploma certificate in nursing with over 20 years of experience teaching both undergraduate and postgraduate students. She has progressive experience in teaching and research in human rights, international humanitarian law, reproductive and sexual health law, medical law, health law and policy, research ethic, clinical legal education, and the law of tort. So she has presented her research works of both local and international conferences, some of which have appeared in international journals. She is currently a member of editorial board of the International Review of the Red Cross Geneva, and also a member of many learned societies. To Ms. Folake Tafita, the floor is yours.
Thank you very much. Thank you for having me. I really want to appreciate the organizers for this conclave. I have learned a lot in this past 2 days, particularly the last speaker, Dr. Bharti. Thank you very much. Please, I would want my slide to be shared. I have
Yes, ma'am. Yes, ma'am. Sure, sure. Give us a minute.
So while, okay, thank you very much for the slide. Okay, so while the slide is on, can you see the slide, please?
Yes, ma'am, we can see, it's visible.
Okay, please, can I have the first one?
Yes, it's there. Okay.
Okay. So I'm going to be talking today about the role of the law school in the teaching of legal ethics and professional responsibility. Let me start by talking about the Nigerian experience and what it used to be. Nigerian colonial heritage, by reason of colonialism, we adopted the British legal system, and which is more of theoretical education. I know the British legal system has moved away now a bit from that, but it seems Nigeria is still hanging on to that. And I want to say particularly that the teaching of legal ethics and professional responsibility is very contemporary, this particular topic that has been chosen, because now we're having a crop or a breed of legal practitioners that are now abandoning the conservative model of the profession. We see a lot of professional misconduct. We see a lot of unethical behavior, both within the bar and the bench. And this is not restricted to Nigeria alone. We get reports from other jurisdictions about this. And it is very important that as law teachers, we have to go back and relay the foundation so that we would have a new breed of law professionals for the 21st century. So in Nigeria, going by my first introduction, we have a national law school, which is the Nigerian Law School. And this Nigerian Law School is the only first exposition to practice and professional rules of responsibility. But now, with the introduction of clinical legal education, things are changing, and
I think we have lost her. Lenny?
Yes, Dr. Folake, hello?
In a new, can you hear me?
Can you hear us?
Yes.
Yes, we can hear you now. We can hear you now.
So when I'm talking about the law school, I'm talking generally about the faculties of law. I'm talking in the inclusive sense. I'm not talking about the National Law School again. So my topic today is referring to the law schools in general. The law schools in general. Can I have the next slide, please? Okay, so talking about law schools, universities teaching theoretical law, I feel that we have a unique responsibility, and we also have a profound opportunity now to inculcate legal ethics and professional responsibility in the students. Apart from the fact that we have this profound opportunity, it is also a legal responsibility on us as law teachers. From the perspective of the law of torts that I teach, I feel that we stand in locus parentis to the students to ensure that we bring them right into the profession. And also based on the principle of the law of torts, duty of care, I feel that we have a duty of care to these particular students. Apart from that, we also have a moral responsibility to our society as an ivory tower. Next slide, please. So teaching of legal ethics and professional responsibility for me would involve the adoption of 3 processes that are didactic, normative, and pedagogic. These are, teaching models or teaching modes, ways of learning that have been propounded by teachers and managers of teacher education, which I feel that is very important for us as law teachers in the teaching of legal ethics and professional responsibility. Next slide, please. So for me, I think that we need to catch them young, right from the day that they resume in school, and we'll take them through that process until the day of graduation. Then we start doing, giving them orientation, both formal and informal, in terms of teaching them. Thank you. Next slide, please. So here I have the College of Law, Chrisland University, Abeokuta model. Chrisland University, Abeokuta College of Law is a very young faculty. We actually got our license sometime in November last year. So this is our first set of law students. So we have decided that we're going to start on a very sound footing. And with that, part of our vision and mission statement is to produce a new breed of law students that will be grounded in legal ethics and professional responsibility. So the first thing that we did when the students came in is to have an orientation program. And during that orientation program, we were able to, talk to them about the law. We were able to talk to them about the legal profession, their mode of dressing, the need for comportment and courage, then their mannerisms and the culture of the law profession. And also we had a welcome cocktail for them. And during the welcome cocktail, we invited reputable members of the profession, both from the bar and the bench. And also, we also attended some functions with them, functions where they were privileged to meet senior members of the bar and the bench, and they have conversation with them. Apart from this, we also mounted in the college a law creed. We mounted it in a strategic place in the college where we have the mission and the vision statement, and we have about a 7-point law creed for the law students, to imbibe, to always read and have as a mantra. Then we also have the student handbook, the general student handbook, and we also have the specific one for the law students. Apart from this, we have the mentoring program that is both individualized and general, and we mentor them along academic and professional lines. Next slide, please.
You have 2 minutes left, Dr. Folaki.
Okay. Yes, next slide, please. Okay, so Christland University is a co-educational Christian institution. So we also teach them about moral and religious instructions. Then we take them through the clinical psychology and counseling clinic, because a lot of them are coming from different backgrounds. We want to know exactly what their background is. Maybe it's affecting their academics or whatever. So we try to, during the process of mentoring, we get to know more about them, and then we can refer them to clinical psychology clinics if they need. And then we also have a discipline and sanctioning process, which we tell them right from the time of the orientation. For example, recently we launched the community service way of sanction. Next slide, please. So recently, the National Universities Commission came up with the core curriculum minimum academic standards. And in the College of Law, we have tried to design some courses. And these courses is to ensure that we inculcate this appropriate and acceptable legal ethics and professional responsibility in our students. So the next slide, please, is going to show these courses that we have designed, and we are employing clinical legal education, pedagogical and andragogy methods of teaching. So these courses are Introduction to Legal Ethics, Introduction to Clinical Legal Education, Community Lawyering, because we have a community law clinic, and then Contemporary Law Practice, then Introduction to Law Office Practice, and Paralegalism. So we believe that this particular courses that we designed for various, for each of the levels would help in inculcating legal ethics and professional responsibility in the students. Thank you very much.
Okay, thank you so much, Dr. Folaki, for the beautiful presentation. And hopefully you have been done so many wonderful work. And because me personally, I also interested in reproductive rights here in Bandung. Okay, so next presenter is the one and only, the last but not least, Miss Natakan Champutong. So, Anne, are you there? So
Yes.
yeah, she just like my sister from different mother. I knew her for maybe 10 years, yeah. And so it's so good to see you again. So Miss Natakan Champutong is a migrant workers and pro bono assistant, developing committees of practice. She also a legal trainer in PepsiCo. And she is a regional legal trainer of PepsiCo, where provides technical and education advisory support for clinical legal education program throughout Asia and globally. She has 5 years of work experience in coordinating legal trainings and curriculum development field, and she is the lead trainer and supervisors in regional CLE extensive clinic for students and law teachers to strengthen their teaching and lesson plan development using CLE methodology. She began her career as legal fellow with PepsiCo in 2012 and became a regional legal trainer in 2014. She also been working with education sectors, nonprofit organizations, legal community, and community regionally and internationally. She also a regional coordinator for the Legal Ethics and Professional Responsibility Program, which has been implemented initially in Thailand, Myanmar, Vietnam, Cambodia, and Laos. So to Ms. Natakan Champutong, the floor is yours.
Thank you, Leni, for the introduction. Good afternoon, everyone. Namaste and Selamat Siang. I am Anne from PepsiCo, Thailand. I am a lawyer and legal trainer at PepsiCo. I am also a former CLE graduate. It's my pleasure to be here today to talk about legal ethics and professional responsibility, which is fundamental to the legal professions. To start, let me give you a brief overview of PepsiCo. PepsiCo is a not-for-profit justice education organization. We collaborate with law schools, legal community, and justice organizations. Our focus is to develop and strengthen justice education, pro bono program, and clinical legal education in Asia and worldwide. You have already heard from our wonderful panelists that law school plays significant role in teaching legal ethics and professional responsibility. And I agree with Professor Bhatti that legal ethics can be taught with collaboration, not just practitioners or law schools, but different institutions and organizations can collaborate on these. In my presentations, I'll be discussing how justice education organizations like PepsiCo and practitioners can support law schools to teach these critical courses. First, let's talk about the important why teaching legal ethics and professional responsibility is important. I believe we agree that legal ethics and professional responsibility should be taught at law school for many reasons. And this is just as important as other substantive laws. Firstly, legal ethics is relevant to legal practice, and teaching legal ethics helps prepare students for real life scenarios. As a lawyer, you have to make choices all the time, and students should be prepared to do so. They should learn ethical decision making and understand the potential conflicts that can arise between their personal ethics and external ethical frameworks. Secondly, it is crucial to instill professional ethics at an early stage. There have been suggestions to teach legal ethics earlier in degrees and of course throughout the degree, so that students have a better understanding of their obligations and responsibilities as a lawyer throughout their legal careers. And they will commence their careers with awareness and understanding of how to be ethical practitioners. Also, teaching ethics in law school can change or improve the public's negative perception of legal profession and maintain public trust in the legal system. As law school provides students with the opportunity to learn and apply these principles in structural settings before they enter the professional world. For these reasons, law school plays an important role in producing and shaping ethical, competent legal professionals. Then we say that it is an important subject and should be taught to law students, but how it should be taught and what should be taught. Let's discuss this further. Teaching legal ethics at law school should be more than just imparting knowledge, but it should also instill a sense of responsibility and morality in future lawyers. Because it is not just a set of rules. Legal ethics also reflect the values and beliefs that guide lawyers' behavior. So students should not just learn the principle or how to apply it, but also be encouraged to discuss the purpose of code of ethics and why they are important for legal professions. The course should teach how to recognize ethical situations and use ethical principles to make better decisions. It should help students understand and appreciate their role as legal professionals and the ethical duties and values that come with it. These are some of the topics that could be covered. Lawyer-client relationship, duties of lawyer to the client, duties of lawyer to the court, duties of lawyer to other constituencies, conflict of interest, confidentiality, pro bono service, and obligation to ensure access to justice. And moving on from what should be taught, let's look at how it may be taught. I think the course should be a combination of theoretical and practical approaches. It should include interactive and reflective methods. Interactive methods such as case studies, role play, simulation exercise, and guest speaker can all be used. You can also involve local lawyers and practitioners in your teaching, or incorporate legal ethics components into other areas of the curriculum. Thanks. As we have seen, teaching legal ethics and professional responsibility is crucial for legal profession. NGO and practitioners can also play a vital role in supplementing law schools' efforts. In 2013, PepsiCo recognized that many universities in Southeast Asia teach legal ethics in theory or as part of the subjects. And the courses do not provide a deep understanding of legal ethics on topics such as confidentiality and conflicts of interest. The students do not appreciate legal ethics and see how it works because of the traditional teaching methods. So we partnered with law firm to develop a comprehensive training curriculum on legal ethics and professional response.
2 minutes left.
Thank you. On professional responsibility. And the curriculum uses various teaching methodology, and it has a clear lesson plan for each topic. It provides a foundation for ethical professional responsibility and the reality of legal practice. It includes games, role play, movie, case study, debate, and also personal stories, which allow students to expose to experienced practitioners who are facing ethical dilemma. I just want to show you one of the example of the exercise. This is the yes/no voting game on ethical situation. In this exercise, students will be asked to think of a situation that deals with area that is ethically gray or possible subject to disagreement, and these are some of the situations that students will be discussed. If you want to, you can use a yes or no reaction to respond to the questions. This Fogacer exercise aims to encourage students to discuss the idea that ethical values are not all the same and vary between individuals. Ethical issues are often complex and difficult to resolve. It is sometimes not as simple as finding a yes or no solution. Yeah, and we can move to skip another example of the exercise. Yeah, this is just another exercise which client would you act for, which the student will be discussed the factor that will impact the ethical decision or the value of a lawyer to choose the client they will represent or not represent. And after drafting the curriculum, we held several training at the university partner in Southeast Asia, and we revised the curriculum and deliver it to universities. And they can apply the curriculum to their existing course or in the legal clinic. Yeah, and this is how we support and work with law school in teaching legal ethics. And if you are interested in incorporating the lessons or teaching methods in this curriculum into your class, please reach out. We will be happy to share the material with you. Thank you.
Thank you. Thank you so much. It's been a wonderful presentation. And speaking about the module and everything, we're still using the Babsicle teaching methodologies module for our CLE class. And we ask students to download it, and then we use it as a daily teaching activities. So thank you so much. So that will be all for the 4 panelists. Thank you all for the presentation. So I will hand it to Professor Devendra Singh for the next step. What should we do, Prof?
Thanks, Lenny. I think this is a wonderful presentation from all the panelists, but there are a few questions if we can take quickly. Can I ask from Dr. Bharti?
Yes.
If you could more explain that what type of structure is required in a law school to inculcate the habit of this ethics and professional responsibility among the law students in Indian context. And if you say something, then keep in mind whether we should bring the advocates, lawyers, attorney to the law school, or we should send the the students to the course for that? Please, if you can answer this quickly, because you have a very wonderful presentation, and I hope you would be explaining to the audience.
Okay,
Thank you very much. Thank you very much, Prof. Very glad to
Tapita, you
answer
please stay rest for a while. In the next question to you, it is for Bharti.
Okay.
It is for Bharti, and next question would be you. This is from your own presentation. It is from the presentation of Bharti, and question is to Bharti.
Okay, this question is for Bharti.
Yeah.
Okay.
First of all, I would like to thank Professor Devendra for asking me such a relevant question. This one question has the essence of today's topic of presentations. This make me think that what changes can be brought in the curriculum or structuring of legal education in the law school. In my opinion, first of all, we need to understand and acknowledge the relevance and importance of ethics and professional responsibility, which needs to be taught to our students, and that can be better exhibited. When we don't restrict this course on professional ethics and responsibility, which is mandated by Bar Council of India, just to one course. As of now, in the Indian scenario, we have one specifically designated course on ethics and professional responsibility. But if in addition to this course, we try to incorporate an element of ethics and professional responsibility and clinical component in all the subjects which are being taught in the law school, this can, give them a balanced understanding. It can give a balanced and comprehensive understanding to students that learning any subject does not only mean learning what is written in your books, but it also includes that how you practice that for the people for whom you are learning this theoretical knowledge and understanding. And in India, we have projects for all the subjects, and these projects are generally focused to enhance the skill of research in the students. In my opinion, if we give focus for ethical learning also, then the project component of the subjects can, in addition or alternatively, be designated for ethical clinical projects being incorporated in each of the subjects. Second thing is, we know that in the India, academicians who are full-time academicians cannot practice law before court. So we need to collaborate. For collaboration, the institution should understand that how important it is to incorporate these clinical courses, and they should support and come forward for signing MOUs with these agencies who are the main crusaders of promoting justice in our country, be it court or legal services offices or any such similar organization. So proactive role on the part of administration to facilitate collaboration. So that the teachers, the respective subject teachers could add this element of ethics, professional responsibility, clinical component in each of the subject and give students an experiential learning. So in response to Professor Devin's sub-question that whether the lawyers and judges should be brought to the class, or should the students be taken to the real environment and to expose them to experiential learning? In my opinion, this learning and understanding of ethics and professional responsibility should not be restricted to have lectures from the practitioners. That's right, that it has its own relevance. We should not take students directly to the courts or to other agencies. We need to have some orientations first in the law school, in the classroom. That orientation can be given by the advocates, judges, but it should not be the sole criteria for offering this course or component. After the orientation session, the students should be taken for the live experiential learning, and which can be facilitated through the collaboration. And for that, we need proactive efforts from the part of the agencies, of the administration. Next is when we say that we need to add this clinical component or ethical practices component to each of the course, we need to train our law faculties. When we look at the refresher courses and other courses, most of them are theoretical course-centric training programs. When we understand the relevance of periodical trainings for the law teachers so that they could enhance their skills, we should also have some training programs for the clinical teacher, and so that this clinical component could be added to all the schools. And the last point.
Thank you. I think you have made valuable suggestion, and
which
can be implemented by all of us at our own level for the law schools. I think you have very rightly explained to the audience.
Thank you, sir.
Now, if I may ask Tafia. As Tafia, you are there?
Yes, I'm here.
Yes, thank you very much for the presentation, and that was good presentation, and the experience which you have shared with us is regarding the lawyers and attorneys are part of the law school in your country, which you just explained, and they are taking attendance register, discipline, and all that. What we want to know more, that if the lawyers and attorneys become part of the department and they take the classes like us means like teachers, don't you think it would be a conceptual clarity? What we understand in common parlance and in clinical legal education, that is professional responsibility and legal ethics is a little bit practical subject. If you can explain more out of your own experience, which you have just said that they are part of the department. So how could more be practical exposure to the student for this ethics and responsibility can be given? If you can explain on more on this to audience, please. I hope I could clear the question.
Can you hear me?
Yeah, we can hear you.
Okay, so concerning the question, I feel that lawyers and advocates should be part of the teaching of legal ethics and education. Can you hear me?
Yeah, we can hear you. You can go on.
Okay, should be part of teaching in the law schools. For example, in the College of Law, Chrisland University, we actually engaged the services of some practitioners, and we take them through the legal clinic. At least they have an orientation of what our legal clinic is, the clinical legal education, and we also tell them about our expectation and how to engage with our students. For example, we have one on the payroll of the school right now. And from my own experience as a nurse, when you have professions like this that it is necessary to acquire skills and practical knowledge, it is important that the students interface with the practitioners in the field so that there could be a marriage between the theoretical and the practice of law. For example, in the medical profession, you see medical students going to the clinics, the clinicals, having their clinicals, going to the teaching hospitals with their logbook, trying to look for cases. And part of what has been done in class is what they are asked to do in the hospitals. So it's the same thing that we should start practicing so that the students can be exposed early to the skills and the experience of practicing as a lawyer. It is not until they graduate from the National Law School that they would have their experience in practice. So in a subtle way, like I said earlier, we can start by catching them young, bringing these lawyers and advocates, to talk to them. And besides, I also mentioned about comportment, dressing, and these are part of the things that they will tend to learn, mannerisms. These are part of the things that they will tend to learn from these practitioners. And I think students, what they see tends to make a lot of impression on them. And we could see this from the orientation week that we had with the new students, and also the we had a dinner, a cocktail dinner, a welcome cocktail for them, where they actually met with senior members of the bar and other legal practitioners, and they were taught to, and they were admonished, and they were encouraged concerning the profession that they have chosen. So I believe that it is important, and it should be the norm, and should not be the exception. Particularly in Nigeria, unlike in India, we are not restricted as teachers from practice. But at the same time, because we need to give time to academics and research, we may not be able to give that practical experience. So we need to call in the lawyers and the advocates. Thank you very much.
Thank you very much, Tapita. I think we all learn from your expertise and your experience which you have shared, because there are conflict in India, whether lawyers be brought to court or students to be sent to court, and you have part in your law school. Attorneys are part of this, and you have explained this. I think this would be very beneficial to us. Now, may I hand over for further discussions and questions to Lenny, please.
Okay, thank you so much, Prof. So I would like to give questions to Mr. Rosa and Ms. Nata Champatong. Are you still there, Mr. Rosa and Anne? Okay.
Yes, Lenny.
The questions will be the same for both of you. So you, both of you already told us about the teaching the legal ethics, while Rosa concentrating teaching legal ethics, how to deal with the community, while Anne give us example how to teach the legal ethics to the students who deals with the clients and everything. So if you don't mind to share your experience, so based on your experience, how you measure something ethical and unethical to the students, because for some people, we might have a different perspective about it, especially in Indonesia. We put the things always related with the local cultures. So probably Rosa will answer first, and then Anne can answer later. So please.
Thank you, Lenny. And as I mentioned before, our emphasis is to give our student opportunity to provide explanation to the community about how the ethical lawyering is. So here in Indonesia, most information about lawyering or trial, people can get from news, from television. And some of those news are bad publication about how our court, perform. Like there is a riot in the court. There are lawyers who pull, I would say, stunt in the courtroom and make commotion. So through the education about how ethical lawyering is, it will bring our student into realization. How should we perform and act according to ethics of law and according to the local wisdom in our culture, and say what you just see in television about trial that went bad, and that's a bad thing, and it's not good example for that. So by making that statement and give that information to the community, I think students also learn for themselves, because through teaching, sometimes we also learn about the thing itself. I think that's my response for that the previous question.
Okay, so which actually you still jump into the community and see how it's going is also really important for students to experience some things, right, related with this ethical teaching. Okay, to Anne, please. Anne, are you still there?
Hi, Lenny. Sorry, please can you repeat the question again?
How to measure based on experience, how to measure that something is ethical and unethical, because for some people it could be very different perspective. So based on your experience, how you teach that and how to measure this is ethical, this is unethical.
From my experience from the training and teaching the student, the decision will be making mostly based on the ethical principles. In our training, we will have in the materials, we will have the exercise where students have to make decision or choose the clients that they will represent or not represent, and they will discuss. And this bring to the discussion about the factor that will affect or impact the decision and how they use the ethical principle to make decision based on this, which can be the area of law or the work schedule of the lawyers or the feeling that's opposed to what your client stands for. For example, you may not want to do the case on trafficking of drugs, or it may be your thoughts on the seriousness or importance of the legal need. Yeah, I think ethical response or the measure of ethics vary from person to person, because people get their ethical value from different internal and external sources. Yeah, it can be personal value and the ethical principles.
Okay, thank you so much, Anne. And I think also it's really important not only teaching ethics, but showing, right? Show it because most of us are teachers, so we kind of like have to give a good example to the students what is ethical way to do something. Okay, so I think it's been a lovely session, and thank you all for all the panelists, and thank you so much for Professor Javender for the collaborations, and it's been a great session. So I hand it over to you, Ms. Ujwala.
Thank you, Professor Dr. Devendra Singh. Thank you, Leni Vidhi. It was a wonderful session. And I request all of you to join us for the closing session also. We have now 45 minutes break, and let's have a quick lunch, and then we can resume after 45 minutes for the closing session. Thank you all. Thank you so much. Thank you.
Thank you very much.
Thank you, sir. Thank you very much.
Thank you, Ujwala ma'am, Devendra sir, Leni, for this wonderful opportunity. Thank you so much.
Yeah, after 45 minutes, we resume. Thank you.
Sure.
Yeah, thank you.
Good afternoon, Fred. How are you?
Hi, how are you? I'm doing well. How about you?
Yeah, nice to see you, Fred, after a long time.
Absolutely. It's a pleasure. I'm sorry I look a little sleepy because it's 3 o'clock in the morning here.
Hi, Dr. Mary Frank. This is Prasad from Goa. Nice to see you.
Such a pleasure. It is 3 o'clock in the morning here too.
Yeah, I
so
know. I do understand. I do understand. For us, it is a lunchtime. We just finished the lunch.
And I just had coffee.
Yes, yes. Probably this is evening for Australia.
It is indeed. Prasad.
Yeah. Hi, Jeff. Jeff, nice to see you.
7:15.
Oh,
Hello,
okay.
Fred. Nice to see
Hey,
you.
Jeff. Boy, it's been
pleased
ages.
to meet you, Mary Lou.
Oh, so nice to meet you too, Jeff. It's nice to meet all of you.
Jeff, it's been so many years since I saw you last.
That's right. I was thinking it's probably you came to our conference in Caloundra.
Correct.
Is my guess, Fred.
15, 18 years ago or?
Something like that. Yeah, long
Yeah.
time ago. 15 years, I would suggest.
Whoa. Huh.
So, yes, it is a long time.
Yeah, well, it's great to have Prasad bring us all together. Mary Lou, where are you? You're in the East Coast of the US?
Yes, yes, I am right outside of Atlanta.
Oh, okay.
Hello, good afternoon, Mary. Good afternoon, Fred. Ujjwala this side.
Good afternoon. Fred,
How are
where are
you?
you located?
Hello, Prasad.
Hi, Ujjwala.
Thank you for joining. We'll start in a few minutes.
Oh, yeah. So we'll wait for another 3 minutes because 1:45 was the time given to them.
That's fine, Prasad.
Yeah.
So how are you? Are you well?
Yeah, I'm fine. We are doing well. Recently, we started a new project.
Yes.
On Prevention of Sexual Harassment Act. Tells us all education institutions, everyone should have the internal committee. So under the legal aid program, we took up the project of first strengthening all the higher education institutions. Now they have the internal committee in place. We were helping them to constitute proper committees, and we trained them how the process that would take place.
Right.
And now we are going to the higher secondaries, then going to government. So it's a phase wise. There are about 4 or 5 stages.
Okay.
It's a new initiative, so we are calling it a law compliance clinic.
Right.
So there are at least there are 3-4 major acts where that everybody need to comply. Another one is the Right to Information Act. All the government and public sectors should provide at least minimum disclosure norms. So they should put certain information in their websites and all. So the next project would be on that to see whether they're doing or not. So we are diversifying now.
It sounds good. It sounds very interesting.
Yeah, but we started as a project, then we thought, why can't we create like a clinic, that kind of thing. So we would be maybe in another 4-5 months, we would establish the clinic. So good afternoon to everyone. It's 1:45. So we are in the last session of this wonderful conference spread over for 2 days. Can everybody mute your mics, please? So I know it's a very difficult session for the Indians because we are just finished our lunch and try to open our eyes without closing them. And I know that Fred and Mary Lou it's too early morning for them. It's midnight, 3 o'clock. So thank you for everybody joining. And Fred and Jeff and I have a better timings. So the last 2 days, I would say that there are a lot of discussions happened in the conference. Particularly, we are looking at how the legal education should be transformed into justice education and what kind of challenges that we have. And particularly when we are listening to different speakers from different regions, realize that there are many places that they are similar to Indian challenges that we have in India, how to transform legal education into justice education. And similarly, we also had kind of, I would say, the consensus that the major goal of the justice education is to improve the access to justice, though we have different models, particularly the law schools working through different clinics, how the access to justice is improved or at least made an attempt to improve in their regions. The clinical legal education emerges as a major player in providing this access to justice. But again, when we looked at the policy initiatives, and of course I have not much experience in other countries, at least in India, we have looked at the policy initiatives towards bringing access to justice to the people through legal education lacks a lot of reforms. And when we compare with the number of reforms on the legal education, most of them talk about how competent the student should be, and those initiatives are towards their improving their competency rather than their relevancy in the society. Therefore, as the legal educators, we need to focus more on it's not only how to make the lawyers competent, but how they are socially relevant. How do we create the barefoot lawyers for the benefit of the civil society is a challenge for all of us. And the conclave also looked at how the students could be used to bring the social change in the civil society and in government and non-governmental agencies. We have seen several interventions by different law colleges. And there are two sessions focused. One on teaching pedagogy is today's morning session, looking into various effective methodologies that could be used in the clinics is a very important aspect. And again, we looked at how do we supervise these clinical activities. Still, we have no clue on that. Each one has a different style. There is no one uniformity that we could find. And then the most important aspect is how do you teach the ethics? That is a fundamental question that was raised, though in India, for the benefit of others, the professional ethics was made as a one compulsory course with 4 credits. But again, how do we offer that course? That is most important. The methodology of offering such course is important. So let me congratulate the new law college and particularly the Ujjwala Shakalkar for putting all these things together to run such a wonderful conclave. This is the second. I think there is more to come in future. So with these few remarks, as we all know that there are 3 speakers today, and I was told that the Dr. Ujjwala Bendale is not able to join for the welcome address. So we will straight away start with the presentations. How does this happen is that each speaker would speak about 15 minutes. And then we will open this for the question and answers. And I request the participants, if you have already some questions in mind when they are speaking, maybe put in the chat box. And if you want them, particularly whether it is for Fred or Jeff or Mary Lou, you can just write to them. Or if it is a general question, you just write a question. So we will take the questions at the end. Okay. So our first speaker is Dr. Fred Rooney, a good friend of mine. He graduated in American Latin Studies from Moravian University, JD from City University of New York School of Law, Masters from Marywood University. Fred Rooney has been credited with creating a law school-based incubator model for justice for being a catalyst in the transformation of legal education in United States. So Fred Rooney and Incubation Center goes together. It is almost become a synonymous for each other. The powerful incubator and post-graduation movement has begun in the legal education 2007, forcing the law school to think their responsibility to graduates and the plight of millions of individuals in the US. So in June 2013, Fred completed a 10-month Fulbright stint in Dominican Republic, where he launched the first postgraduate legal initiative outside the Caribbean. So for the activities that the Fred was done, he was named by the American Bar Journal as a legal rebel in 2013, recognizing him as a father of incubators. So then he started as a director of Toro Law Center, International Justice Center for Postgraduate Development, and currently he is an attorney at law. And we are really fortunate to have Fred for today. Fred, we would like to hear from you and your incubator, etc. Please, the stage is yours. I may little interrupt in between when your time is getting over. Please excuse me for that. So I present.
Thank you. Thank you, Prasad. Thank you so much, and thanks for everybody who is joined with us this morning, this afternoon, and this evening. I can tell you that I graduated from law school in 1986. I went to the City University of New York Law School, which was a brand new institution that was using law. The mission was to use law in the service all of the law schools in New York, but there was a law school that was specifically designed to deal with the millions of New Yorkers who had no access to attorneys, no access to justice. What I learned when I got out of law school and then started to practice law is that law schools don't really teach you how to practice law. Unlike medicine, where you go in and you learn as a first year med student, you learn how to deal with the practical application of medicine. Law schools, not only in the US, but once I started traveling, realized that they just don't teach you how to practice law. They teach you how to pass the exams, pass the bar, and then you're on your own. And so when I got out of law school, I was really stifled. It was stifling because I had to really develop the skills that I should have learned when I was a student. I practiced for a good number of years, and fortunately I had good mentors in my community to help me along. But about 12 years after graduating, I went back to the City University of New York because 4 law schools in the US came together, the deans came together and said, we have too many of our graduates who are going out to practice, to set up community-based law practices, and they fail because they just don't have the skills. They don't know how to run a business, which is a law firm, and they don't have the professional training. So I think that for the first time ever, law schools began to realize that they had a duty to continue to educate their graduates. And that was something that the Carnegie Foundation came out clearly in favor of, law schools continuing to educate once they were gone. In New York, we started the first program to bring our graduates back on a weekly basis to train them in the areas that they desperately needed to learn. We found out very quickly that when you're a student, you take the classes for the grades. When you're a lawyer and you need the skills that you should have learned in law school, you become very, very interested in learning. So they were coming back to the law school for the first time ever. And so little by little, the network of our graduates grew from 10 lawyers who were coming back for training to 10 to 20 to 50 to 100 to 300. We knew that lawyers were desperate to be able to serve their communities, and they needed the skills to be able to do that. So we would teach them, all that they needed to learn in business law, in business, how to run a practice, sustainable practice, and how to deal with immigrants. So for about 7 years, we continued to support our graduates, but always in the back of my mind was this idea of, if we could bring, it would make training so much easier and so much more consistent. But there was really nothing like that. I searched and researched to try to find programs of postgraduate education for lawyers, and there was really nothing out there. Someone mentioned to me, asking if I knew about incubators. And I said, yeah, when a baby is premature, they put them in an incubator till they survive. And they said, no, we're talking about a business model. I said, no, I had never heard of it. This is 2007. So they said, well, go out in New York and see if you can look at some incubator models. And I did. I went to an incubator for graphic designers. I went to an incubator for bakers. I'm thinking, like, if bakers and graphic designers and small startup companies can be trained in, people can be trained in incubators, why not try to see if we could use it to train lawyers? And so the real challenge was to retrofit the business model to deal with the legal system and what lawyers needed to do. So in the back of my mind was a pilot project for 9 lawyers. Let's see how. So we had, in 2007, 9 of our graduates come under one roof. We opened up an office in Manhattan. And it was really quite magical because the lawyers were very.
Fred, we are losing you in. Fred, can you repeat?
Applied learning.
I think we lost
I don't
you
know
at
where.
point.
Yeah, so we started a program in New York City, 2007, and it was to bring together 9 lawyers. It was a pilot project at best. The New York Times heard about it, reported on it, and then the whole notion of a legal incubator went all over the United States. So from 2007 until today, I have been bombarded by mostly law schools initially, and then bar associations who really wanted to try to create programs that would train individuals interested in starting community-based practices by providing them with the professional skills and the business skills they needed. And so the little pilot project in New York City then began to take on wings. And over the course of the next several years, there were 2 incubators, and there were 3, then there were 10, then there were 20, then there were 30. And by, say, the middle of 2015, 16, there were about 50 or 60 programs that spun off of this pilot project. I was flabbergasted because I had no idea that what we were doing was going to be anything more than a small project for 9 lawyers. In 2000, as Prasad said, in 2015, 2012, I was given a Fulbright scholarship to see if I could replicate the model outside of the US. And I went to the Dominican Republic and started the first incubator to train young Dominican law students in their last semester of law school and new lawyers. And it was really quite remarkable to see how well the model that we started in New York was able to be replicated in the Dominican Republic. By that time, there were probably 50 incubators that were spread out all over the East Coast, West Coast, Los Angeles, San Francisco, Chicago, Miami. It was just mind-boggling to see how they started opening up like wildfire. After I realized that the model was a good model for replication outside of the US, and after the Dominican Republic, I got another Fulbright and I took the model to Pakistan. And I was traveling back and forth between Islamabad and New York to create the first incubator for Pakistani lawyers. After that, and just before the pandemic, I was Roma, to provide them the training that they really needed in order to survive. And most recently, I've been working with the UNDP to start the first incubator in the West Bank in Gaza, in Palestine. So in December, we launched the first incubator on the Gaza Strip, designed primarily to empower young Palestinian women who have historically been underrepresented in the legal community. It's been quite amazing to see how the model that we started could be replicated in a place like the Gaza Strip. I'm going to be going back, I think, next month to start 2 incubators in the West Bank, in Ramallah and in Nablus. And so last week I came back from India, and I was in India for about 3 weeks working on a model to really design to help issues that farmers face.
Fred, can you repeat about India? We lost.
Decimated by. I'm sorry, the connection must not be that good. Yeah, I came back from India last week, and I had been in Pune, I was in Delhi, I was in Jammu, and I was in Assam. And we were looking at the issue that farmers face in India. And with the unfortunate rise in suicide because people are unable to be able to keep their farms. We know that there's a crisis, and that oftentimes the families left behind have so many unmet legal needs. So the Indian model we're hoping to launch will be able to train lawyers in the incubator on how to deal with issues of land, how to deal with all of the collateral issues that farming families face, and so the incubators can really be crafted depending on what the unmet legal need is. In the United States, there has been an incubator that was created for environmental issues, training young lawyers on how to deal with environmental issues. U.S. have focused on housing, consumer issues. And so, I feel very confident to say that no matter where we go with the model, it can be replicated. And what it does is it really provides young lawyers with a deep commitment to social justice to develop the skills that they need to create sustainable law practices. We know that in all of the countries around I would say almost all of the countries around the world, the issue of access to affordable, competent legal services is very poor. In the United States, we rank as way down the countries able to provide equality, justice, fairness, is hard to have the money to be able to afford the cost of hiring a lawyer. The wonderful thing about incubators is it gives young people for a period of a year to 18 months the ability to develop their skills. And while they're being incubated, they use those skills in underserved communities. We connect with legal services programs, we connect with law school clinics, and it really has helped them develop the skills. It's allowed them to really fulfill their dream of becoming community-based lawyers. Like myself, 40 years ago, when I was struggling to be able to create a sustainable law practice, they now have the helping hand that they need. And so when I look at the issue of the programs in the US and then in the Dominican Republic and Pakistan, there's another incubator that is in the process of being developed in Spain. And I will be back next month also in Albania and Romania. So I thank everybody for listening to the story. I feel like I'm trying to say a lot in a short period of time, but I would if you have any interest in a program that really allows young people to develop their dream of serving in marginalized, vulnerable groups, people who historically have been shut out from the ability to access competent and affordable legal services. Prasad, I don't know how I'm doing time-wise. I'm trying to.
Yeah. 3 more minutes you have.
Okay. Initially, some of the biggest concern about incubators came from two places. One is bar associations, and the other was clinical programs. Bar associations said we were providing unfair advantage for our lawyers, incubator lawyers, and clinical programs said they're going to do away with the need for clinical programs. The other program was legal services, and everybody thought that we were going to come in and try to revamp the legal system, and that's not true. Little by little, bar associations began to see the value of the incubator model, and so what was initially opposition became a real desire to get on board. So the New York City, Chicago, Los Angeles, bar associations, Memphis, Tennessee, all over the country began to create their own incubators. And our biggest and our strongest allies have become clinical programs. Clinical programs are the best feeding ground for young incubator lawyers because during the period of time they're in a clinical program, they develop practical skills, which students who don't participate in a clinical program oftentimes lack. And so we work very, very closely with clinical programs, with bar associations, and then probably the biggest source of referrals come from legal aid programs. Every country tends to have a legal aid program, but we know that the numbers of people who are served based on the fact that they have to comply economically is very low. And so in all the countries I visit, all the places I travel, I see that we all have one thing in common, and that is people of modern, young, compassionate, and well-trained lawyers can be there to help deal with their unmet legal needs. And I believe that and I can say this with all honesty, incubators are not the answer to the problems around the world, but for the people who get trained in them and the people they ultimately serve, an incubator has become a godsend. And so I really would encourage anybody, again, to reach out to me. I can provide you information, all of the information that we have developed, all of our best practices. It's all open sourced. So if you think about an incubator, you have any desire to maybe consider one, we will provide you with almost anything you need in order to get it done at no cost. This is really a passion for so many of us to see access to justice increased, not only in our own countries, but around the world.
Thank you, Fred. Thank you, Fred. That is a wonderful presentation, and we got an overview of how your incubation centers works. I think probably I met maybe 10, 15 years before that time. You were just setting up these things, but now I could see how it has grown over the period and all over the world you are. So we are very proud of that moment that you have started. So our next speaker, we had a very versatile person, Dr. Mary Lou Frank. When I read her a brief bio, I said, my God, so many things she has done. So I may not be doing justice. A brief bio of to introduce Mary to you. She is a psychologist, court-approved mediator, mediator trainer, author, and consultant. She had served as a university vice president, dean, professor, adjunct professor. Currently, she is teaching at Brenau University, Mercer Law School, Middle Georgia State University, and Michaelas Ramirez University. And most importantly, her text, The Mind of a Peacemaker, The Psychology of Mediation, is its third edition and was listed by Book Authority in Conflict Resolution for 2022. She served as a president of the International Academy of Dispute Resolution, received numerous awards for teaching, community service, leadership, and diversity. She has an international honorary doctorate from the University of Georgia, and Dr. Frank serves on International Women's Think Tank and heads the International Law School Tournament Board for the International Academy of Dispute Resolution. She is the co-founder of Transforming Mediation LLC. Dr. Mary Frank, I present her and request you to speak.
First of all, thank you so much, and I'm very humbled by your introduction of me. And it is always a pleasure to get a chance to, and I'm always very humbled to get a chance to speak at these, because the work you're doing is so important. And I'm really honored to follow Fred, who has done some amazing work, certainly starting in the United States, but taking it around the globe to really make a difference. And hopefully I can add some other pieces to what he has done from a little different perspective, because I think most of you are attorneys. And even though I teach it, have taught at several law schools and places all over the world, my background is psychology. So my background's a little bit different. And I'm, like I said, I hope I have some things to offer. I'm going to go ahead and share my screen a minute, because I have some slides that I will talk through while I'm doing this. Can you all see it now?
Yes.
Okay, good. I always want to make certain, because you never know on these things if you're really able to see or not. This conclave, when I went through the list of all the topics that were covered, and my kind, the person as you introduced me and you introduced the session, I was impressed with all of the things you've done. Each one of these is important, and each one of these has the potential to really transform our world. And what we all want is a better world, not just for us, but for our children. And I think taking what we've learned and then saying, is there something else even behind that that might allow us to be successful? And I am going to humbly suggest there may be some other ways that we can bring some things that we can take to each of these programs that we develop, whether they're in law schools or they're in communities or they're in curricula that we're developing, that might make things even better. An African proverb says that you can't lead anyone further than you have really gone yourself. And that really speaks to the piece. And there are a lot of people who claim this quote, but as I searched back, it looks like it comes from a proverb out of Africa. And it's saying that we need to understand ourselves before we can really be able to take programs or change to another level. So what I'd like to do, looking at the the pieces of democratic education as really a process that's drawing forth our own power to make a difference in our communities and even in our world. I'm going to look at four things that we don't often talk about, but I think underscore any of the work we want to do with ethics, underscore any of the good work we want to do in law schools, or any of the work we want to do in our communities to make a more just society. The first thing I think we have to ask is something that many times we give a quick answer to, and that is, are we really being honest with ourselves and honest with other people? I think sometimes it's hard for us. And in groups of attorneys and groups of psychologists and groups that I've worked with in different countries, it's easy for us to say, well, of course, we're always being honest, but sometimes we have other issues. Sometimes we're trying to work something else out that we really haven't finished working out on ourselves. I know in the work that I do in mediation training, one of the things that I find most often, and the research has borne it out, is that most people who are serving as mediators, and the majority of which are attorneys today, have difficulty dealing with people's emotions. Now, when I first saw that, I was a little surprised, because attorneys would ask me, who'd been practicing as mediators for many years, they'd say, but what I really don't know how to deal with is when people get angry. And I thought, isn't that interesting? Because many times you think people go into law or go into these professions knowing you're going to be dealing with angry people. But they said, help me learn how to deal with people who are angry. And if we're really honest with ourselves, that's true for many of us. And then how do we deal with our own anger? How can we work through that? So then we're able to help other people, because we can't walk people through it if we don't know how to walk through it ourselves. And it means being honest and open to being fallible. I know I am. And I've been at this for a number of years, but I learn every single day. I learn something about myself that allows me to help the groups and the people that I work with, to help them be more successful, because I've worked through those issues and I know how to help take them through it as well. The second piece is respect. And again, it comes across as a very simple concept, something that all of us probably think, why, of course we know how to respect each other. Martin Buber, over 100 years ago, said, we have to, though, if we really want to understand respect, to develop confidence as we encounter people who are newer and different. Be able to bring that to everyone and to accept people before we judge them. And sometimes that's hard to do, because we have different lenses through which we view people. I know oftentimes when people hear I'm from the United States, they have beliefs and ideas of what that might mean, because of everything we've heard and read in the news. I'll never forget, I was in the United Kingdom a number of years ago and was doing some presentations. And just at the same time as I was doing presentations, the then president of the United States was making statements that left the rest of the world aghast. And so every time I met someone, they told me what they thought about the current president. And I said, I understand. I said, I can't control that. And it was only when I went in to take a cab to go somewhere else, that when the cabbie asked me, so where are you from? And I said, oh, I'm from the United States. And I almost started apologizing. And he said, you know what? He said, all of us have had leaders that say things that are different that we may not agree with, but we're all just people, and we need to accept everyone as people and not try to layer any kind of expectations that we might have heard or have about where they come from. And I thought, what wisdom from somebody from a fairly simple occupation, but what a wise man he was, that we need to learn to accept people and believe that there's something inherently respected for each one of us about being human. And that especially is important when we're working with people who may not be just, who may be a part of processes that are really hurting and not allowing other people to grow and to be able to flourish. The third piece is bias, and we all come with them. It doesn't matter what country we come from, what religion we come from, what part of the world we come from. There are biases that were inherent in our society, and we need to honor those and look at those and start by looking at those within ourselves. Because sometimes I've worked with people who say, I have no biases. And those are the ones that I worry about the most, because we all were brought up with those, weren't we? We all had things when we were growing up, we had in our families, even if it weren't our parents, we had people in our families who said things like, when you get married, I want you to marry people from this religion or from that ethnic background or from that part of the world. We all heard those, and those were a part of our stories growing up. And to think that those aren't still with us is naive, because we carry all that unless we take a minute to look at ourselves and say, we need to work through those if we're going to work with people who might be different than us. Because even though we think we've set all that behind us, because now we have degrees or we have training or we have whatever background we have, we carry that with us until we work through it. And then maybe we can start learning to accept people for who they are and see how important that is. So we learn by looking at shared experiences and realizing that bias is everywhere and that it's in us and not a them. We can learn to develop compassion first for ourselves, and then we can become compassionate toward other people. And that is the highest calling we can bring to all of the issues that this conclave has brought about, is learning how to bring that compassion to the important work each one of you and each one of us has to do in this world. The final thing that I want to touch on is trust. We need to learn to trust ourselves, then we can learn to trust other people. And then we can learn to start learning, we can learn how to start trusting each other. And trust is even deeper than just respect, because it means we are going to allow ourselves to really be open to support and work with other people. And even sometimes people we don't agree with. A few months ago, I was asked to come in and work with a group of judges and attorneys out of Ukraine and teach them about being mediators. And I want you to know, and I've worked with people who have been in the middle of conflict before, but never in such a place where they were all in the middle on a daily basis dealing with war. And what I learned, I was teaching them about mediation, and one of the pieces I talked about was the power of forgiveness in mediation. And one of the judges raised her hand and said, "Ma'am, you need to know I could never trust the people we're at war with. I could never respect them because they're not people. They are killing our people. They're doing untold damage to our country." And I listened to her and I said, you know, I bet I would feel the same way if I were like you. And I said, it's really hard to imagine what you've gone through. And then I went on and continued talking about how in mediation and when you work with people and when you're trying to find peace, how important it is to be able to bring that compassion and maybe even at some point forgiveness. We worked through, it was an LLM program, and we worked through the program. And in the last session that I had with them, we were talking about what they had learned, and she raised her hand and she said, "Professor, I need to tell you something." And I said, "Please help me, because I've learned so much from all of you." And she said, "I could listen to these people now. What I've learned is I could listen. It might be difficult, but I've learned the power that I need to learn to listen, even to people who have not been fair or kind to me." And I was so touched by that, because I knew the power that it has to bring ourselves to being the best people we can be if we are going to ever be able to bring peace and justice to this world. So when we are more honest, we can learn to be fair with other people. We can learn with respect to be more civil and bring civility to these communities and to these programs that we want young lawyers who are going to change this world to bring with them, to bring bias, to be able to address our biases and work through those so that we can come to a point of compassion. And finally develop trust so that we can be able to bring the support and action to these important programs that engender social justice. Each of these are important, but it comes at a deeper level when we draw forth our own power of looking at ourselves and making certain we are ready. Because we know this, without justice, we won't have peace. There is no peace without justice. But to understand either, we really need to understand ourselves and to know who we are so we can bring our best selves to the importance each one of you has to this, because it begins with each one of us, not us versus them, but us versus us. I'm going to stop here and realize that I've got Jeff is going to be joining us in just another minute or two, and I want to hear the wonderful words of wisdom that he has. But I thought I would share that with you. Am I close on the time? I'm sorry, I can't hear you.
Prasad, unmute yourself, please.
You have 1 more minute, Frank, Mary Frank, if you want to use it.
Certainly. Well, certainly that's been my journey. And it makes sense, doesn't it? When you come at it from psychology, you have to learn to work, when you're going to work with change and people or groups or whoever you're going to work with, you have to then learn how to work with yourself so you can be the best agent of change. And I've had training at many different universities and certainly I've worked with many different law schools. But what I've learned makes that piece, that small piece that seems so terribly insignificant and many times is not a part of legal study, can make the very best lawyers, is those people who have insight into themselves. And it doesn't mean they have to, but I know that with that extra piece, it allows them to bring a degree of compassion to their work that makes them even more effective and more powerful. Thank you, sir. Thank you so much.
Thank you, Dr. Mary Frank. Such a wonderful presentation. And that's how a psychologist coming to law school and teaching, it's wonderful to see that how a different perspective the lawyers and the law students and as a law teachers, we learn from her. It's a kind of an eye-opener how these kind of skills that a lawyer required. And it's really commendable. Thank you very much. And it's a privilege to hear to you, Mary Lou. Now the next speaker is Jeff Giddings. Jeff and I had several encounters. We met several times online mostly. And Jeff Giddings is an Associate Dean, Experiential Education and Professor of Law at Monash University. He joined Monash University law faculty in 2017 after working 22 years at Griffith Universities in Brisbane, Queensland. Jeff remains an adjunct professor of Griffith Law School. He continues to be an adjunct professor there. He received an Australian National Teaching Fellowship in 2013 for Effective Law Student Supervision Project. Jeff also received Australian Award for University Teaching in Law and Legal Studies in 1999, along with multiple Griffith University Teaching Awards, including the inaugural Griffith Award for Excellence in Teaching. From 2013 to 2015, Jeff served as an international scholar for the Academic Fellows Program of the Open Society Foundation, working extensively with the American University of Central Asia. Jeff has written extensively on clinical legal education and established the Griffith Clinical Legal Program in 1995. And in 2010, he completed his PhD, and his PhD is also relating to the clinical program, that is sustainability of clinical legal education programs. His thesis was subsequently published as a book, Promoting Justice Through Clinical Legal Education by Justice Press. And to inform all the audience that this book was translated into Mandarin in 2017 by the China Renmin University Press. Jeff is also a co-author of Australian Clinical Legal Education, published in 2017 by ANU Press. And more than that, Jeff is such a gentleman. We had a great time together in most of the conferences. So over to you, Jeff.
Thank you very much, Prasad. It's an honor to have been asked to participate in the conclave. If I may, I would like to start by acknowledging the traditional owners of the land and waterways that I work on. The people of the Kulin Nation here in Melbourne and surrounding districts, to acknowledge them, and that I work on land that was never ceded by them to the colonial powers that came here. And I think that's important for many reasons, but certainly in regards to thinking about democracy and thinking about educating for democracy and that roadmap towards justice. I think that achieving justice with our First Nations people is particularly important. So it was really interesting to hear what Fred had to say in terms of clinical programs being a major supporter of incubators, and that certainly fits with my sense of the community of practice that can be generated by a clinical program, which sees students become involved and then continue to work once they have completed their law studies in related social justice fields. And I would endorse Fred's view that there is flexibility in regards to the use of these models. They can be tailored to work effectively given the particular circumstances that are involved. I was also interested in Mary Lou's reference to the mind of a peacemaker. There's a great quote from Abraham Lincoln in which he makes reference to, as a peacemaker, the lawyer has a superior opportunity of being a good person. And it's interesting to think in that term. Lincoln talked about discouraging litigation, persuading neighbours to compromise whenever they could, pointing out to them how the nominal winner is often a real loser in terms of fees, expenses, and waste of time. And that is, to me, a sentiment that's important for us to be thinking about as legal educators. The other insight that I thought I would make reference to in relation to Mary Lou's presentation was she talked about us versus us. Well, that's very appropriate the day before India plays Australia in a cricket test match. So that's the, I hope you have a lovely day tomorrow, but I hope that your cricket team doesn't win. I'll leave it at that at this stage. So now to the important matter of thinking about how we can, I would describe it as feed the fire for social justice that is so important for many of our law students. And to me, the students come in and the clinical program is very often a place in which it's possible for them to engage in activities that I would see as important as far as taking us along that road towards justice. So I will mention a range of clinical activities and offer them as suggestions. And if anybody wanted to talk with me further, then please look me up and send me an email. I'd be delighted to have the opportunity to make your acquaintance. So the first type of clinic activity, I use a broad definition in relation to what clinical legal education includes. I see it as being about students learning by doing and reflecting on what they've done with a focus on ethical, reflective practice. I don't think it has to be one particular type of activity other than it involves work for an individual or a community to assist them to understand and act on their legal rights, their human rights. So it seems to me that the many programs, and I see that we are joined today by Lenny Mulyani from Indonesia. Hello, Lenny. And of course, Lenny is a terrific street law educator. And it seems to me that street law is a really important aspect of or important part of what's available to us as educators for getting students involved in community-based activities, which see them outside the law school into the community in a range of ways. And we have very useful resources that we can call on in relation to operating street law programs. There's a fantastic book that was edited by Professor David McCoy-Mason, which is called Street Law and Public Legal Education. There are, Lenny's got it up on her screen right there, as mine's not coming up with the background I've got. So that's a great book which provides useful examples for the ways in which street law, community legal education can best be done. And it includes examples from around the world, including one from here in Australia, where two students of mine were doing a presentation in relation to democratic rights at elections. And also the book by Professor Richard Grimes, Public Legal Education, the Role of Law Schools in Building a More Legally Literate Society. And I would see that as being an important task for law schools and for clinical programs in particular to be involved in, that fostering of legal literacy. Then there are a wide range of other clinic activities that have a strong community focus. we can think about outreach services where students go and visit or live in marginalised communities so that they learn to understand what's important to the members of those communities and then act effectively to assist those communities and individuals to, as I say, effectively participate in democratic processes, to effectively advocate for their interests and their human rights. So that's going to be really important. At Monash, in our clinical program, we have an emphasis on students being involved in a range of community engagement activities. These tend to be research projects which see the students needing to engage with a particular interest group to deepen their understanding of what will be important to that community and to offer proposals for reforms of unjust laws or better practices in relation to the way in which laws are implemented, consultation processes, and so on. It seems to me that clinics also have an important role to play in terms of working with law school colleagues to provide what my dean, Professor Brian Horrigan, describes as giving a voice to the voiceless, identifying areas where there is a need for law reform and then advocating on behalf of traditionally marginalised groups to enable changes to be made. And I wanted to offer an example. The Australian federal government was involved in a seriously flawed system that was seeking to recover what they described as overpayments of social security entitlements to millions of Australians. It became known as the robo-debt scheme because it relied on algorithms to estimate the levels of overpayment in many circumstances where there was no overpayment. This was a dreadful system which is now the subject of a federal Royal Commission of Inquiry. One of my colleagues at Monash Law School, indeed the director of Monash Law Clinics, my friend and colleague, Associate Professor Joel Townsend, was involved in the running of test case litigation to challenge the operation of that robo-debt scheme. Joel has now used the insights that he gained from that work to pursue or to, if you like, lead the submission of a paper to the Royal Commission offering a shared view from 10 academics within the law faculty in relation to not so much who's at fault and who's to blame, but what can we do to make sure this doesn't happen again? And what are the changes that can be made that will improve the system so that this will be avoided? It seems to me that we can also, in clinical programs, we can make use of the effective supervision practices to draw out and reveal the social justice dimensions of the work that we are doing to our students, and then talk to them about those. And I think that's really important. So if I can talk about matters related to fostering democracy, I would note that there are some really important qualities that I would see that underpin democracy, and that I wouldn't confine that to Australia, but I would have thought they operate in many places. And I'm thinking about tolerance, I'm thinking about respect, about being open to diversity and dissent, being respectful of the rule of law. And for lawyers, we really need to be actively promoting adherence to the rule of law. I think we need to be advocating for open government, as well as for ethical conduct. Those are the sorts of important aspects that are going to be significant to fostering a respect for and an understanding of democratic processes. What we then can think about, it seems to me, is that we can work in ways that advance those by modelling those qualities to our students, so that we're not saying one thing and doing another, but rather we are actively demonstrating that we see those matters as important and modelling how that can most effectively be done. I also think there's real value in us sort of making use of that notion of thinking globally and acting locally. And that involves looking at organisations like the Global Alliance for Justice Education. I note that the Global Alliance for Justice Education was involved in supporting this conclave. And I also note that both Professor R.J. Pandey and Lenny Mulyani are colleagues of mine on the steering committee for that organisation. So those of you who haven't encountered Gage before, I would encourage you to take the opportunity to engage with Gage, pardon the pun, as much as possible in terms of working together and collaborating. So Prasad, I've probably used up most of my time.
About 2 minutes?
2 minutes, okay, thank you. I would just say that here in Australia, it's really important. We are going to have a referendum later this year in relation to whether or not we should enshrine an Aboriginal and Torres Strait Islander or First Nations voice to the federal parliament, and enshrining that in our constitution. To me, this is a really important step in terms of reconciliation between our First Nations people and the colonial powers who came to this country. And that's going to be particularly important. And I see a role for law students and for clinical programs in providing information to community groups and individuals that foster clear understandings and respectful conversations in relation to these significant issues, ones on which there's a diversity of opinion and there's probably some fairly ill-informed opposition to that type of proposal. It won't surprise you, I imagine, to know that I'm a strong advocate for the passage of that referendum. So if I can just finish by commending New Law College and the organisers of the conclave for addressing this important issue of that roadmap to democracy, and thank you for listening.
Yeah, thank you, Jeff. Such a wonderful, meticulous presentation and taking us into how we should behave in the clinics and what we can do, and also for those two wonderful resources that you have shown us for all of us. Now the forum is open for the question and answers. Anyone would like to pose a question? You could raise your hand and they would unmute yourself and speak. Yeah, Malar.
Hi, I'm Malhar from the National Law School, and I'm a part of the Legal Services Clinic in the law school. And we've been working on a lot of projects since the past year. And some of the flagship projects that we're doing right now is the Prisons Project, where we visit prisons, interact with the authorities, and identify areas where we can intervene effectively, like making applications for statutory bails where pro bono lawyers don't show up, helping inmates get access to justice in a more effective manner, and to sort of streamline the whole process of justice delivery there. So I was just wondering as to how to best channelize the current limited resources that any law school clinics generally have into getting maximum output from the activities that we routinely undertake. Now that is in the aspect of our legal aid. We do programs for legal awareness as well. But I just want your input as to the general trajectory that we're going in and how to maximize the output.
Jeff, would you like to respond?
Thank you, Prasad. Malhar, I suggest that it's difficult from a distance to offer you advice as to what's the best way forward, but it does seem to me that what we know about good practices in relation to clinical programs is in part about how we prepare the students for that experience, so that the more effectively trained and prepared you and your colleagues are, the more focused the work is that you do, the more likely that you will achieve the outcomes that you're seeking. Of course, that's sort of framed in terms of, given a certain amount of resources, you need to work with those effectively. You also need to look for ways to grow the resources that are available. And it does seem the PhD research that I did on the sustainability of clinical programs emphasised or revealed the importance of support from law school deans in the operation or to the long-term success of clinical programs. there are lots of factors that are involved, whether they relate to general economic and policy circumstances, whether they relate to the interests of the university and the structures that the university uses, but there are local law school factors which will always be really important. And they relate to working using what I've referred to in the book as an integrated framework, which sees clinical programs working with other aspects of a law school, other parts of a law school, so as to bring those more conventional academics into the work of the clinical program and to see it work both ways. It seems to me that that's going to be really important. Good luck with your work.
Thank you. Thank you, Jeff. Any more questions, anyone? So I'll take this opportunity to ask a question for myself, and I'm asking this to Dr. Mary Lou Frank. Mary, how you think that you spoke about 4 things that honesty, respect, bias, and trust is very important in peacemaking. But do you think they are also important for the lawyers who are otherwise engaged in litigation? How do you impress those lawyers? Because mostly lawyers are very hostile to each other. So how do you impress these law students that these are important for them?
I would sit back in experiences that I've had, and please understand, I'm doing this from someone from the outside looking in. So it's always easier for those of us who are on the outside to make comments. But in the work that I've found, if they want to be the most effective lawyers they want to be, then they will have things like honesty and respect and know how to deal with bias. They will know those things. They will be compassionate because they can be very strong in terms of their arguments, but that doesn't mean that they have to be disrespectful to other people. I think we know that by looking at our leaders, don't we? As well as people
Mr.
who are
Nitin, Mr. Nitin, can you please mute your mic, please? Yeah, thank you.
Thank you. So yes, I would say if they want, certainly I think you can exist as an attorney, or I would even say as a psychologist. You can exist out there saying, these aren't important. I'm going to be a hard scientist, or I'm going to be somebody who just gets things done and makes as much money as possible. And we have people in both of our professions that do that, and they do that very well. And maybe if I did that better, I would be much more, I would be wealthy and would have all these things, but I wouldn't have the peace of mind that I have, that when I end my day, I can say, I think I've made a little difference. I've made things a little better. And for all of us, I don't care whether we're attorneys or whatever, isn't when we get to the end of our lives or when we get to the end of our days or weeks, don't we want to sit back and say, I've made a positive difference? Not that I got as much money as I could that week, because we know that that's, in the long run, that has very little to do with our happiness. But if we want to make a difference and really make a difference,
yes,
and I'm certainly that's true of all my colleagues on this Zoom meeting today, that all of you want to make a difference. Then we're going to look at ourselves. But I also, the work I've done with law schools, people say, this is making me a better person, not just a better lawyer. And I said, you know what, that happens. Sometimes they say we're kinder to our families now. I had one attorney came to me after several months. He said, I'm listening to my wife now, and my relationship with my children's better. Why? I just wanted to be a better mediator. And now all of a sudden, I think I'm a better person. I said, well, that can happen.
Yes.
I think that's perfectly
Yeah.
acceptable.
Yeah.
I hope
I
that
agree.
answered the question.
Yes, I agree that even though lawyer is a hired gun, but still honesty, respect, bias, and justice do help them to become a good lawyer.
Prasad, there is a question in the chat box.
But I'm going to respond to Dr. Lakshman. You said how practically it is possible. What do you mean by which one you want to adopt? The whole conclave, what we discussed, or any specific? Lakshman, can you please unmute yourself and tell us?
Hello.
Yes, Lakshman.
Yes. So absolutely, it's a wonderful program, and I want to. Really, I felt it was so nice that this program, how to become a part of it and how we can conduct this particular, program. And at the same time, practically all these clinical aspects, what other university people, they have, explained, So we practically find it difficult to adopt as such in our curriculum, So by classroom teaching, along with that, this kind of, exactly the practical clinical aspect. Is it, really to adopt in our curriculum? See, I am a professor in this thing, Pune University under the organization, DY Party. So that's what I felt. So that's the reason why I just posed this particular question.
Okay. So he wanted to understand how practically it is possible to bring all these things under the curriculum.
Yes.
Anyone particularly would like to make a comment? The speakers? Yes, Jeff.
Thanks, Prasad. I'd suggest that it's certainly realistic to work in ways that foster a greater understanding of the potential of clinical legal education, and that will be with a range of people. I don't think we need to, students already understand how valuable this type of learning by doing and reflecting actually is. Generally, the judiciary will be very supportive and interested. The organisations that regulate legal education will also be convinced as to the value of having students going beyond thinking like a lawyer to acting like a lawyer. And that will be really important. So I think it's about patient building of networks where different clinical legal educators can support each other and work with others. If you look at the way in which there have been great clinical legal educators from across the globe who have willingly taken the opportunity to work with their colleagues in other countries to develop opportunities. Fred made reference to Fulbright scholar positions that he had held. Certainly, there have been lots of US clinicians who have taken the opportunity to contribute to clinics and access to justice movements in other countries. And likewise, there are lots of scholars who've taken the opportunity to visit the US to be involved in developing their understanding and capacity for collaborating and working together on these sorts of issues, as well as to contribute their insights. So I would have thought that the message is a positive one in relation to the range of opportunities and the ways in which we can work together.
Thank you, Jeff. And being from India, you could look at Lakshman in two ways. One is it mandatory for you to start this kind of activities? Either fortunately or unfortunately, Bar Council of India has mandated that every law college shall have a clinic. And all the final year students must be part of the clinic. That means every law student in their final year must undergo a clinical program. Therefore, you could think of, you have seen so many clinical examples were given by so many people. So you think, depending upon your strengths and weaknesses of your university, your college, what is feasible to you to start with. So these are the examples that you are going to look at and maybe choose, make a hybrid one. It all depends upon your conditions, how your college is placed, where it is placed, what kind of students you have, what kind of curriculum you have, flexibility in curriculum. Based on that, you can decide. In fact, now you can go back to your college, please call few teachers, few students, sit with them, brainstorm and see what you can do. Okay. So most of these things, most of these things are started by voluntarily somebody, and then it has grown up to this level. I could take one more question if anybody has. Okay, it looks fine. So it's a very enriching closing ceremony, closing session. Really happy to have Fred, Mary Lou, and Jeff for this session. Could you please somebody's mute your mics, please? Manjusha, can you mute your mic? Thank you. And Fred spoke at length about the incubators, and we are all really curious how these incubators are working. And he has given an open invitation to anybody who is interested, could contact him. I believe you could check in the chat box. He has given his email. That is what all the clinical law teachers, they are very informal. They are open to share their knowledge. We are happy. This is one of that initiation to have this kind of networking for all of us to learn from each other. Thank you, Fred, for sharing your details, and really looking forward. Probably by next year, we are thinking of having incubation centers to open in Goa. Definitely, I'll be in touch with you. Then, when I looked at Mary, I know that she's going to bring something different to today's conclave, and then that's what exactly she has done. And we really realized that lawyers are not just hired guns. They need compassion. They need to be different people. So she has brought all those 4 areas, how they are important in peacemaking, but they are also important for all the lawyers and law teachers. Even law teachers could learn. For example, when I looked at particularly the respect bias, I think teachers also should respect their students. They should respect what they are, what kind of their ideology. When my ideology doesn't go along with the student ideology, how do I deal with that? So it's really enriching experience. Thank you, Mary. And as usual, Jeff has clearly indicated how the clinical programs works and the various issues, challenges. So therefore, after listening to all of you, there are many takeaways. We have seen different kinds of clinical activities offered by different regions, different colleges. So all of us would be looking at those models, maybe kind of making some kind of a networking to learn from each other. That is what I'm going to take back today, and it is always nice to have attended Gage, but unfortunately I missed for last Gage meeting, missing that actions to some extent. Ujjwala has brought us back to those memories. Thank you, Ujjwala, for putting such a wonderful conclave and from the comfort of our home. So,
thank you.
I don't have the problem of visa, nor where do I get funding, how do I travel, all these problems are not there. We are sitting. So before I'll hand over to Ujjwala, let us say a big thank to Ujjwala for her such a wonderful initiation.
Thank you.
Over to Ujjwala.
Thank you, Professor Prasad. Ladies and gentlemen, a very good afternoon and warm greetings from New Law College, Bharati Vidyapeeth, deemed to be University Pune. It's an honor and pleasure for me to propose vote of thanks. We have come to the end of the conclave, but beginning of something new wherever we work within our space and within our capacity. The 2 days have been very engaging. We learned from each other's experience. Some success stories shared were inspiring, while we also identified some common challenges we face as justice educators. We are grateful to speakers, panelists, moderators, participants joining from Indonesia, Malaysia, Cambodia, Thailand, Saudi Arabia, Bangladesh, Nepal, Iran, Poland, United States, Australia, and India. In fact, they joined their sessions working from different time zone. 1:30 a.m. I'm informed, and 7 a.m. I'm informed, and at all odd hours. We are thankful to them and appreciate their dedication and passion for justice education. Heartfelt gratitude for you all. I also thank members of the organizing committee, Professor Syed Masood Noori, Professor Ajay Pandey, Professor M.R.K. Prasad, Professor Anisa Sheikh, for their continuous support during conclave and before the event. In the entire process, we were blessed with guidance and support of Professor Dr. Ujjwala Bendale, Dean Faculty of Law, Bharati Vidyapeeth, deemed to be university, and the academic flexibility required to conduct event of this magnitude. We are appreciative to her. Last but not the least, we send our greetings and well wish to all participants from all over the Asian region, and I'm sure they must be benefited as we are. Thank you, student volunteers, technical support team, and my colleagues here. I'm glad that we had intellectually enriching conclave, and let us all continue collaborating for the cause of justice education. Thank you one and all, and see you all soon. And now we can have a good group photograph. Anisa Sheikh will be making an announcement for that. Over to you, Anisa.
Yeah, please can you just put on your camera so we can have a group picture? All participants, presenters, all guests, please.
Thank you all. Thank you so much. And see you all again. Thank you. Thank you very much.
Thank you.
Bye, everyone.
Thank you, everyone.
Bye, Puthi.